Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next church on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? The people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, welcome back from lunch. Welcome back to the Court of Public Opinion. Thank you for joining me. Appreciate being here. We have a bit of a photo finish. A photo finish for first place on First in Chat. I don't think we've ever had anything like this. But simultaneously, I think we have Ines, Jill Ballard, Kim R, Britta Aller, Stephen Blevins, Krista, and SF in Texas, all that came in like simultaneously. As a matter of fact, I've been getting screenshots from various people saying on my screen it shows I'm first, and on another screen it shows someone else first. On my screen I show Ines was first. But I don't know. So apparently we're going to have some split duties on internet ownership today, which is, I think, appropriate because there's a lot of the internet. There's a lot. I object as well. Anyway, I want to say thank you to all of you who made the valiant effort to get first in chat. Ines, on my screen, it shows you win. So although everybody might have the responsibility of internet ownership today, I think it only goes down on your permanent record. So that's where we're going to call it today. But thank you very much. I appreciate that. Thanks for being here first in chat. I'm not even sure if you saw it on the screen. Was that on the screen? Oh, no. Please tell me you guys could see that. No, it wasn't even on the screen. I literally clicked on everybody's names in order as they were on the screen.
Kick back, taking it easy.
You saw it on this screen, right? You know I'm not lying. I had proof, even though I can't bring it back up now. I am excited to get underway for our second part of the day for the Maya trial. As we've got a little bit more of defense witnesses on the stand. I think we've got witnesses today. We've got witnesses on, well, today's Friday. We've got Sally Smith on Monday. And I don't know who else they might be calling, but by Tuesday night or Wednesday morning, the defense is expected to rest. So that's gonna be exciting. Christy Sinnott, welcome to the gallery. Thank you so much for joining us as a member. Make sure you take a seat, type ! Seat in chat, and help yourself to the emojis. A few other things we got to do here this morning. I forgot to do. I don't think I did our Zen moment, did we?
Scratch all that. Oh, that was
scratch
terrible.
that.
I apologize.
That was terrible. Let's see. I was showing you. We have some calming images to look at from these three trees. Past few mornings have been beautiful with the fog. I think this one right here was this morning, and it looks a lot like 2 mornings ago, but the fog is different. Right there, that was this morning. There was a beautiful fog bank that was burning off. I was racing my car trying to get it. Don't miss the forest for the trees. There's no there's a forest way back in the back, but that's like almost a mile back, and those are the only 3 trees in the field. But anyway, there's your Zen moment where we're get ourselves centered, and there we go. We're ready to go. And those pictures are available on these 3 trees on Instagram. So I promise to keep posting more over there. All right, good to have you back here. There were some questions. Let's see, did any of you see the interview with Shapiro and Sarasota on the Sarasota Herald? Interesting, all about supporting mandatory reporting. I did not see that. Kathy, thank you for that. OG Sean White just gifted a membership. I know, I think we saw some gifted memberships earlier, and I can't scroll back far enough to see who did it. But let's see. Oh, this is what I need to tell you. Lots of things happening. Let's see, who was it? Yeah, it's gone. Sorry, I thought I could get it. Big changes are coming to YouTube. And unfortunately, the changes are going to be felt more by this community than many other communities. And I'm not happy with it. But for those of us on YouTube that do long form type videos, YouTube is taking away our ability to prevent pop-up ads from happening during the live stream. Yes, that's correct. It's frustrating. I believe November 1st is the date when they finally take that away. They've already changed it so that several of my lives I have to go in manually and deselect it every time. But what that means is that in a long form video, like when we're following a court case, at times that YouTube deems appropriate, whether this is a screen change or something changes on the screen or audio change of some sort, they will insert ads.
You're talking about stuff that is
not relevant. Yeah, we'll do that tonight as well. That is not relevant podcast. But I just wanted to give you guys the warning. I think it's a money grab by YouTube, because the only people that aren't affected by that are the people that pay for YouTube Premium, which is a sizable chunk. But premium users should not notice a difference. But if you're not a premium user, just know that from the day I started till now, I've made it so there are no ads that pop up in the middle of our live streams, and now YouTube's taking that right away from us. So
I'm not a camel.
Bit of a heads up, bit of a bummer. I'm hoping they reconsider, and maybe down the road they'll give us that back. But just as a heads up there. All right. Yo Mama says, member for 6 months. Welcome to the gallery. Thank you so much. Look at that yellow courthouse. Good to have you in yellow there with us. Thank you for your support. It was Ashley and Megan Easton who did the gift. Oh, thank you very much, Kim. Ashley and Megan Easton, thank you for gifting the memberships earlier as well. I missed those. I saw they popped up, but my screen, the tool I use, won't let me go back more than like 100 lines, which when chat gets busy is not very far back. Some have already started based on Rob's chat. Yes, they were phasing it in. YouTube's phasing this in, and so they've been on some live streams. There are people that are getting ads, even though currently I still have the option, and it says that there are going to be no midstream ads. But people are saying, I just got an ad, so that it's being phased in right now. So if you see that, please know I'm sorry. First of all, there's nothing I can do about it. Honestly, financially it is better for creators. It's probably better for YouTube, but I think the viewer is the one that loses, especially when YouTube or a bot on YouTube's side is choosing when to insert an ad, and it could be at a critical moment. It's a little frustrating on that. Hopefully we'll get some more power back on that one. Let's see. Let's see. Jade says, I get ads on live streams. Yes. What? You got it? Yay! I owe my daughter $5 because I told her, if you can kill this bug, it's dead. And you found it and got rid of it?
It's right here.
Yes. Okay. It was just outside. It made it outside the studio door, which means, honestly, it means it climbed behind my green screen. Oh my goodness. It's hung a sheet on the wall. Our house is clean. I'm telling you, we have a clean house, but the bug comes inside and it looks for a place to hide. And no quarters given, right? A little RA. Yes, the bug has crawled its last crawl. I can breathe now. The lavender scent in the air is eventually going to dissipate, but yes, she was the one that spotted the bug and she's followed it. It's funny because these bugs, once you see one, you'll know that's the same bug. That's just all I'll say. Paula Mack says, woohoo, 6 months to love RA community and love our yellow and green Packers colors. For a little while, you get the team colors and then they'll switch.
Cockroach red double exclamation mark. Good job. Pay up, Dad.
Yes, I owe her $5. I told her, if you can get that bug, I'll give you $5. And so now I don't have to be staring all over the wall and worried about every time you say, what's that behind you in chat? Okay, here's what we have as far as the court is concerned. We're waiting for the judge to come back now. I think they are going to be back in about 3 minutes. Let's see. So go Pack Go, says Kelly Waller. Yes, we've got some team colors going right now. Girls rule. My daughter is amazing, absolutely amazing. She is incredibly talented when it comes to art, and she loves it. And so whether it's diamond painting or she actually did a flower, like flowers in a pot, like, on canvas. Okay. she's young. I don't give out my kids' exact ages, but she's young, and she did a little canvas painting. It looks awesome. And she's good at catching bugs and getting rid of bugs for me. Don Burke, welcome to the gallery. Thank you very much. We're about to start with, I think we have the Pharmacist next. That's my guess, if we remember right from what the defense told us. But that's going to be coming up quick. Or maybe, let's see, what time is the jury coming back? Judge said to the jury's going to be back jury's back at 1:40. The lawyer's back at 1:25. So we have 15 minutes of discussion, of arguments, possibly about expert witness testimony. Hang on one second. Let me get the Zoom pulled up. If you guys missed it, I also got a little screenshot of this, so I might use that. I might use that in a picture somewhere. But funny moment from earlier in the day. Squirrel. Okay. I discovered a favorite food now that we're so I saw the guy's face and thought about the pizza description that he gave. I actually had chicken for lunch, like chicken sandwich. And we found a deli meat that has 4-pepper, I guess it was turkey, 4-pepper turkey deli meat. Oh my goodness, that was really good. I can vouch for that. Okay, copy link. Okay, there we go. Zoom's coming up now. Now we're good. We'll have that on the phone. All right. Were there any questions? I apologize. I may have left a question unanswered from a super chat. Super chat on the end of the last live stream. Can you explain the Fabre that the defense withdrew earlier? Fabre has to do with the percentage of responsibility from another party that's not included in the case. So like splitting who's responsible for what. Peter Steele, the way I understand it, this argument is sort of like admitting that you have some responsibility. So the defense has to decide if they want to do that at all. Do you admit you have some, or insist you have none and risk taking all of it? That's in my head. That's what the decision is. The defense has to decide right now. Polly, I did show the wink just briefly. Excuse me. I did show the wink. That's what it was. It was creepy. It was creepier than the still image, for sure. Coffee and Crime just gifted 5 memberships. Thank you so much. Appreciate you being here. That was wonderful. Good to welcome new people here with a free membership like that. That is amazing. And let's see. Where is... I don't like bugs. Who said that? Brenda. I also do not like bugs. My kids get rich. They make more money off me saying I saw a bug, it needs to die, than anything else. They don't need to go out and work because all they have to do is let a bug in the house and they know I'll pay them to get rid of it. Okay. Happy Friday. Yes, Tasia, tonight we have a podcast here on the same channel. The podcast is the Not Relevant podcast. Weather Watch, one of our great mods here, and a good friend of mine, and I will be talking about just some fun stuff to kick your weekend off. It's a way to sort of unwind. We do mention a little bit about what's happened during the week in courts and things like that, but usually we just take a look at some of the fun news stories from around the U.S. and around the world. Have a good time interacting with you all. Usually it's about an hour or so, and hour and a half-ish if we get some good topics going. But it is the Not Relevant podcast, and so we'll welcome you to that if you're interested. Let's see. Do these attorneys have the ability to strike jurors in a criminal trial? Donna, yes, they do. And what we heard from Jules, who's one of our court observers down there, even though she was not there during the jury selection, they did strike a lot of people. JLR's boots on the grounds. Oh, all right. Awesome. We'll have to check in with him. That manhunt up there is still continuing. I've heard they've surrounded a greenhouse now. They surrounded a house yesterday, his house, and had, calling the guy out. And turns out he was not there. Bug Dugger gifted a membership. Thank you very much. And Laura Bronson gifted 10 memberships. Thank you. You guys are most generous. JLR has done some great boots on the ground reporting up there during the manhunts up in Pennsylvania. So just crazy. Please stay safe if you're in that area. Hopefully a quick resolution comes to that one. Christine D says, DCFs either seem to destroy good parents or protect bad ones, and kids never win. Do they ever get it right? Christine, it's a tough one. Generally, I think the ones that get it right, we don't hear a lot about. It's the bad people that make the news. A lot of times, the good news just doesn't travel as far for some reason, and that's too bad because there is a lot of good news out there to celebrate. Okay, judge is coming in right now, so we're going to turn the sound effects down.
Can I see the attorneys real quick?
Judge has something pressing right at the very beginning. And the Zoom is not on, so. Trying to just read body language here. His mouth's obscured behind Mr. Anderson's head, so I can't really see what he's saying. Seems to be to the defense first and primarily. Good vibes, Stacy. By the way, thank you for the very generous super chat. I appreciate that. Just Joy, what trial is next for you? Well, I've got another trial that we're recording right now. It's actually literally going on currently in Adams County, Colorado, which is the trial of Officer Woodyard from the Aurora Police Department. He's charged in the death of Elijah McLean. So we've been recording that. It just continued today, so we're going to be posting that on the other channel, on the Top Mark Media channel, and it's just a straight recording of the court WebEx. I don't think I'm going to go back and rewatch that whole thing and talk it through with you guys, just because the court has done a poor job of managing the WebEx, and occasionally they let it crash and then don't bring it back up for a long time. So there's some dropouts and things like that we have to refresh and try to get back in. It's been difficult to watch, but see, yes, this is the same judge. This is the same judge on that case, and obviously that's one that will be interesting. Another civil trial. Have you looked into the Karen Reed? For that trial, I'm probably going to say I'd defer to Brandy Churchwell.
I have finished the ruling on the objections to Dr. Vose's deposition designations that the defense sent. I don't think I have seen any plaintiff objections, if there are any.
We don't have any.
And so my assistant will be sending those out sometime this afternoon.
Great, Judge. And for purposes of depositions, we do have Dr. Hannah's step ready to go today. It's considerably shorter because at 10:30 last night, the plaintiffs withdrew a lot of their designations after we've all reviewed them. And then we also have Dr. Byrne's deposition ready to go.
And back to Dr. Vose for just a second. There was like one question I had because I didn't know what was actually designated in the page or two before. Okay. So I'll need to know that, and you'll see my handwriting. So that lengthy note that might not be very legible is I need to know what actually was designated in the page or two before.
All right, excellent, Judge. I'll let you know.
We do have one issue with Dr. Hannah's deposition. We'd like the court to take another look. I have a copy of the clip report here, if helpful.
Okay.
And we would, the 403 issue, I can show whatever you like.
Yeah, I just...
Which Hannah deposition?
Okay.
Just about Fern. Is it volume 1 or volume 2?
But okay.
What date? There was a couple of...
It's the November 20th, 2020 deposition.
Okay.
That was the earliest one.
What page?
Page 165, beginning line 1 through line 22.
165.
What are we talking about?
403.
Okay, I'm on page 165. What's the issue?
Your Honor, we believe this is a 403 issue consistent with the court's previous efforts to keep this.
What lines?
And specifically 165.11 through the remainder.
Through 22?
22, Your Honor.
It's outside the presence of a jury, so it
that she
has a little
signed
more
with Dr. Hannah.
leeway.
It's in the records.
Dr. Hannah's medical records.
It's in Dr. Hannah's medical records. It's not one of those blank ones that we had talked earlier about with Kirkpatrick. It's an agreement that she signed and is in the record.
It's also, I believe, signed by Dr. Hannah and a witness or two from his practice group.
We believe if it's allowed in that they will argue that the jury should infer that she did provide it intravenously despite the conversation here, and that's why we moved to the 403, 404 issue.
Judge, there's no question that Mrs. Kowalski provided oral ketamine to Maya, and the plaintiff wants to eradicate any reference to ketamine being given at home. There's already been testimony that she, in fact, did give oral ketamine at home.
We're not simply to strike reference to oral ketamine. We're fine with that. Our concern is the reference to intravenous ketamine at home, which has, on all previous occasions, been excluded.
Well, there's also an exhibit, trial exhibit 2408-1559, in which this witness that we're about to see, James Schott, expresses exactly what is to be, how it's to be used for. There isn't a commercial product for oral use. You have to get injectable and take it orally.
What?
In other words, it's the same substance that could be given orally or intravenous.
This, I guess, let's put it this way. In retrospect, I probably should, starting on line 11, she did ask me for the balance needs to be out.
So what are the lines again, the page lines you want to exercise?
Page 165, line 11, we can leave in because she did ask me, period. And then remove, she did ask me, can I give it IV? Through the balance, which appears to be 165, line 12. Sorry, 165, line 22.
Thank you, Your Honor.
The record to reflect that's over objection, Your Honor.
Understood.
Trying to fix the audio a little bit for you guys. Give me just a minute.
Sure. There's one exhibit we want to put in the use of this with this witness. I'm sorry.
Is it Cottrell?
Yes.
I'm sorry.
Is it Mr. Cottrell? Cottrell. Mr. Cottrell has the control again.
3402. Oh, okay. Sure. I think he's making that edit, Judge. Give me just a minute. There's 2 pages.
Sorry, it's a little hard to read. The message says,
It's the pharmacy record.
CPS saved me as an infant when I was abandoned at birth. There were some amazing people working their hearts out, but we also need to call out the bad when a system has this much power. Lynn, thank you very much for the super chat. Sorry, the background makes it almost impossible to read there. But thank you so much. Thanks for the insight of that. The good stories need to be called out as well.
Yeah, that's a problem.
Wait, Judge, the fact that ketamine's on there is the oral ketamine. It's been testimony that she did, in fact, give her ketamine and Gatorade. I don't know if they want to wipe out all reference to ketamine, but that's testimony, and we believe we're entitled to have the jury know all the medications that Maya was getting. And it says PO by mouth.
Your Honor, this is the record that I was looking at yesterday that they handed me to verify the Dilaudid pump, or if that's the right name of the drug.
Hydromorphone is also known as Dilaudid.
All right, so hydromorphone, Dilaudid, and that's 5-6 entries down. You'll see 2 there for hydromorphone.
I thought yesterday I was told this was already in.
But this is a different.
Yesterday you asked. There was a controversy yesterday over whether the prescription was already in.
Phil.
And then you were shown this yesterday with respect to the question of whether the prescription was filled.
I asked 2 questions. I asked, was the prescription filled, and was the pharmacy records in evidence? And I think I was told the pharmacy records were in evidence.
I don't think the latter, Your Honor.
I don't remember that question, Judge.
No, I apologize if I misremember. Because I was debating, that was one of the reasons why I was letting in the script yesterday.
Now the judge is frustrated. He would have.
Now we've got a document that has intravenous written all over it.
Judge, we're calling the pharmacist, and we're not going to, and he can explain that the ketamine, it says PO, and that's by mouth, and we'll have him explain.
Route intravenous, IVPRN. How many
Where are you seeing
intravenous?
that, Judge?
Well, there's several medications.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16.
Oh, Judge, those are not, the IV ones are not, they're not ketamine. She was giving her IV hydration.
There's no question she was giving her IV. There's normal saline and Zofran and hydrocort that she was giving intravenously. I don't think there's any question about that. But if you look down at the ketamine, Judge, on the first page of this exhibit, the 3 lines up from the bottom, the 2 are ketamine, and the prescription is frequency as needed, and then the route is oral. Now, what Mr. Anderson just made reference to is the fact that if you get ketamine, it comes as one solution. The solution can be IV, IM, or oral. But this prescription is for oral. And that was the only thing that was going to be adduced. The point that was going to be made, that I hope to make with this exhibit, is simply that it verifies that the hydromorphone and the PCA pump were in fact filled, and then it had been my intention to approach the bench or the remainder of it regarding the ketamine. And for that matter, the other IV matters.
They're not disputing the oral ketamine, Judge. And
I have no problem with oral ketamine.
Okay.
For some of the reasons I expressed yesterday, I remain very concerned about this discussion about IV. And because I do feel that there's a big 403 issue. I'm trying to...
Well, do you want us to remove intravenous? Right here. He's talking about the intravenous.
That's not for the ketamine. That's for the...
Your Honor, if the court's going to admit this, it seems the defense's stated purpose is specifically for the hydromorphone, which is at the top of the screen there. So we would ask for the remainder to be redacted, and they can reference the hydromorphone, those 2 prescriptions there for that 2-week period in November.
But even then, what is the relevance here of whether for the trip to Mexico she got hydromorphone? We failed, from the plaintiff's side, we failed to understand, unless you're getting into 403 or 404 bad acts, I guess, what relevance is it to the issues before the jury, whether on the trip to Mexico Maya had hydromorphone available?
Judge, these are prescriptions that Maya was given. It goes towards how much medication she was needing, how she was doing, the fact that she's getting oral ketamine at home, which has already been testified to by the plaintiffs, how much she was getting, because they stood up here and showed a chart to the jury. Here's when she was getting her infusions. Well, in between those infusions, she was getting oral ketamine at home. And I think that's relevant for perspective for how she was doing. We're not trying to imply that she was getting intravenous ketamine.
And I agree, the oral ketamine, I have no problem with the oral ketamine. That, it's everything else in this document, and how is it going to be used is my bigger concern.
Well,
I just...
Do you want us to remove intravenous?
I don't know what I want. I just know, given the years of concern I've had about this issue, the number of times we've talked about IV, I am very wary about this subject, and for the reasons I expressed yesterday, I remain very hypersensitive about this issue.
Okay.
And it seems to me that we also, since there's already been testimony that there's oral ketamine and that she was taking it in 2015, it also seems to be, we're trying to continue to prove an issue that is not a dispute.
Well, except the amount she's getting. And this is oral ketamine in March of 16, in April of 16. There are different months that she's getting prescriptions for oral ketamine.
There's a pattern of oral ketamine, Judge, that extends across the period of time that plaintiffs have been contending that she was doing quite well, and she was a freight train headed to college, and was not needing ketamine treatments. And during that same period of time, these prescriptions indicate that she was in fact getting oral ketamine boosters, that her mother was in fact giving her that. Now, the IV portion of this is not in dispute. There's already been testimony from Dr. Kirkpatrick that he prescribed IV normal saline to be given to this patient by her mother through her port, PRN. That ship has sailed. This documents that it was sailing farther out into the sea. There's nothing to be done with it other than the fact that there it is. It's being done.
The only thing this is for is, again, 403, Bad Act 39 stuff, in that they're trying to argue that she was being given, too much ketamine or too little ketamine, or that the ketamine was helping her get better or wasn't getting better. I don't see those, Your Honor, with respect to counsel, as probative of anything in this case. And if it is, it's cumulative to all the other stuff. And our concern, frankly, is that through testimony of the next witness and skilled questioning, this is going to turn into a Chapter 39, 403 issue. I just sure as shooting, it's going to go right back to that edge and over. I don't, because the only reason, from a trial tactic point of view, to get into this would be to demonstrate that Beata was giving her too many drugs, and that's somehow probative of Beata being a bad person. I don't understand any other way this could come out, and even if there is a superficial reason for doing it, to me, we know how the initial description of the evidence somehow ends up coming back around.
Well, I still maintain that it is fine and not any sort of violation of the court's prior orders that the discussion and evidence relating to the oral ketamine that Maya Kowalski either did or did not take prior to 2016 is relevant and admissible in this trial. Okay. So perhaps what we do is we leave in the ketamine items and then just redact the balance of the document, because it seems like you want the ketamine, and I'm fine with the ketamine.
Well, the hydromorphone. And the hydromorphone.
And what about the hydromorphone?
That's already in.
Well,
that is exactly where they started out going on this, which is to say,
either you get the script.
We got the script.
Either you get the script and we redact the hydromorphone off of this one, or we leave the hydromorphone in this one and you don't get the script.
Okay. That's fair. Okay. I mean, I understand.
which is it?
I'm trying to understand the choice.
Well,
it's one or the other.
You want it two different ways, same information.
And Your Honor is correct. I do want it both ways. And the reason is very clear. Dr. Kirkpatrick sat up there and testified that yes, he wrote this prescription for the PCA and the hydromorphone. Yes, it was necessary for him to do that because of the pain and because his treatment had not worked. But then he said it hadn't been filled. He testified that the prescription was not filled. The document that we're trying to use here, this document, is a document from Courtroom that the gentleman we're about to put on is going to testify, documents, among many other things, that it was filled, that he filled it. That's the point.
And went through Fabre this morning, Your Honor, and so whatever Dr. Kirkpatrick did in that regard is irrelevant.
It doesn't matter. The Fabre does not matter to this judge. The point is
Can we let Mr. Anderson finish his argument, please?
Yes. We have to look at what the impression this is supposed to make on the jury. It is one thing to stand up and say, well, we think it could be as to this, but the clear import is that Kirkpatrick is either lying or giving medications or agreeing that ketamine doesn't work, or I'm not sure what all else, none of which is pertinent to any issues here. If the court wants, and again, the court has been very clear about the ketamine orally coming in because they want to talk about dosing, fine. But as to the remainder of this, all it can go to is either Beata bad or Kirkpatrick bad. It can't go to anything else.
Yes, it can. Respectfully, Your Honor, yes, it can. It goes directly to the point of the extent of the child's disease. They're saying that we aggravated a pre-existing condition. They're saying that she had this condition that we made worse. This shows how bad that condition was, how bad it stayed, how bad it was refractory to this therapy that was going on. It goes directly to that issue. It starts with a hydromorphone and goes right through all the ketamine.
And at this point, I've told you the ketamine, oral ketamine is fine. With respect to the Zofran and the hydro whatever, I again, if you want this document, that's fine, but you're not getting the script as well.
Okay.
And so, okay, so you want the pharmacy record. We need to, redact out all this other stuff.
Okay, can you be clearer, Judge, on what you want us to redact?
The items that are in the script, those items can stay on the pharmacy record. The ones that you're talking about, the hydromorphone, the Zofran, the ketamine, that can stay. That's what you were talking about, right?
Yes, sir.
Go to page 2, Clay.
You'll also see on here, Judge, there's a medication called GammaGuard, that's IVIG, that has also been the subject of testimony. It's not a surprise that that was being administered at home intravenously as well, pursuant to an order from Dr. Barr, who testified in front of this court rather early in plaintiff's direct.
Again, this is designed to create the idea that Beata is giving all of these at home, and then what? Somehow that's doing what? And all of these are prescribed, and everyone knew what she was taking. And I have not yet heard an expert on their part come in and make the arguments, the technical arguments that they're making, that somehow this affected the degree of her disease or an indication of it. So to us, we cannot see where it doesn't either go Chapter 39 or 404 and irrelevant to the issues.
Honestly, I continue to struggle with how medications given in 2015 impact what the hospital did or didn't do, its acts or omissions in October of 2016, and whether the hospital exacerbated a condition that the hospital says that doesn't exist, how that is in fact relevant when I compare it to the substantial 403 issue that I know that is out there that I've been struggling with since the first day I've been assigned to this case. And so
Judge, these are 2016 scripts. So
Well,
we're talking about.
I don't see one that is after.
No,
there's one that was on October 7th.
Are you talking about the ketamine specifically, Judge?
All of this is before.
These are all
all of this is before the hospitalization that we're talking about.
But it's all leading up to the hospitalization, Judge, and it goes to her condition and how much it was taking for her to be as she appears in the photograph.
I'm about ready to just say nothing comes.
Okay.
Honestly, because
she sat down quickly. You see that?
Everyone's arguing so much about this, which further makes it clear to me that the purpose of this is not is different. The purpose of, let me just say this. I remain very concerned about the 403 issue. That is huge, and I know that it's right out there, and I am concerned, especially since we're 6 or 7 weeks into this trial, that we might be walking into a mistrial, and I don't want to have that happen. And I'm just really, 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 really concerned.
All right, Judge. So I understand the court's order or ruling at this point. The oral ketamine stays. The hydromorphone stays. And the Zofran stays. And everything else is out.
What's the Zofran? Why the Zofran? I mean, yesterday was the Dilaudid pump.
It was the items that were on the script, the Dr. Hannah script, which is what they were trying to argue yesterday.
I wasn't aware that included Zofran.
It's
an anti-emetic.
Okay, so it's hydromorphone and ketamine.
Whatever's on that script.
Ketamine's not on the script, Judge. It's the hydromorphone.
You can have the ketamine. I am fine with the ketamine.
All right, so we'll redact that. Over objection. I understand.
Over objection.
So let's show it to the defense before, show it to the plaintiffs before it's shown, and if there's any further redactions, we'll address that.
So we just redact the entire entry medication all the way.
Spiro's so mad.
He's going to go meet.
Why don't you just leave the...
Mr. Spiro is so upset.
Our statement, we will be making objections to the Vos 2019 deposition they intend to play, and we'll have those to the court by the time we leave today. We thought they were planned in 2023. My apologies.
Fanny Pack, welcome to the gallery. Look at this.
I'll be on the lookout
6 months plus.
I'm sorry?
I'll be looking out for the further objections that I have to rule
Yeah,
on.
we've given that.
We also observed Dr. Wyndham. We're waiting for those two.
I don't think I've seen anything with Dr. Wyndham.
We're waiting for them to tell us if they have any objections,
Right,
just like we did with Dr. Bose.
Dr. Wyndham was sent over yesterday evening, I believe, so we'll do that this weekend. Okay.
Yeah, so just to be clear, Judge, sorry, because I thought we were good on Hannah. I just want to confirm. There are no issues with Dr. Burns' deposition. Is that correct?
Mr. Whitney.
Dr. Byrne, we're ready.
Okay.
So what are we doing right when I bring in the jury? What's next?
We're calling the pharmacist Mr. Schott.
And we still are working on the redaction.
We could,
So,
you want to play Hannah?
I'm going to show him his prescription so that he remembers the prescription.
As I've told the lawyers, you can pretty much refresh recollection, but when we do it, let's not carry our script right next to the jury and wave it to the jury as we walk by the jury, which I think I've been always saying.
I can truthfully tell the court that never crossed my mind.
That's fine. I just wanted to remind so we don't do that.
He is offended at the accusation. Look at that
Mr.
scowl.
Hunter, please don't look at me like that.
Mr. Hunter, please don't look at me like that.
You could show it to the other side first.
Wow. Wow. That was a don't look at me in that tone of voice, if I've ever heard it from the judge. The judge brings that up
Have
because Mr. Shapiro was accused of doing that, of holding up a paper and showing the jury something that was not going to be allowed in evidence. From the, what are we going to call it today? Lectern or podium? Lectern. Let's call it a lectern today. Mr. Shapiro earlier held up a piece of paper and as if this was what's on it, and looked down and was reading or asking a question, giving the impression that he was reading off something that the jury would never be allowed to see.
So are we
So
going to
since then, the judge has made that instruction.
as 34021 and 2A?
Yes.
Are we ready to bring in the jury?
And the script is not in evidence, right?
Mr. Hunter
is not in evidence.
Mr. Hunter's doing some deep breathing exercises.
Let's bring in the jury.
Yes, sir.
Wow. Mr. Hunter, please don't look at me like that. This is the judge. Oh my goodness. They had to make a tough decision. The judge said you can have one or the other. I'm not going to let you have both, realizing that this is talking about medications Maya received the year prior to anything happening at the hospital. He's like, how is this even related? You're getting so close to these 403 issues, which is, it's more prejudice than it more goes to attack the family, make them
Members
look
of the
bad.
jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? And has anyone approached you about this case? And any media coverage have you seen? Thank you very much. Mr. Hunter, please call your next witness.
Matt Bond, thank you very much. My spiffy legal
Mr. James Schott.
James Schott. Spiffy legal mumbo jumbo talkie recovery dude. Thank you. Signature phrase from you there, Matt. Appreciate that. Mr. Hunter, we've got some trees for you to look at. Take some deep breaths. Walk amongst the trees. Reconnect with nature. Rob, just had the very last bit of the cross and the discussion about the judge's ruling. Mr. Hunter took offense to the judge instructing him not to hold up a paper as he walked up to the witness to refresh the witness's recollection with an item that's not going to be allowed in evidence, specifically this prescription. And so the judge told him not to do that, and he said that that never crossed my mind, and he glared at the judge and did this scowl. The judge said, "Mr. Hunter, don't look at me like that, please." It's fantastic.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Can you grab your stuff? All that going on here. Just let me see that witness staying there.
Okay, please, Stuart. Good afternoon.
Good afternoon.
Tell us your name, please.
James Vincent Schott.
And what is your occupation, Mr. Is it Mr. Schott?
Correct. I'm a retired pharmacist.
Congratulations.
Thank you.
Okay. Where are you retired from?
My last place of employment was CVS Courtroom.
Okay. And what did you do with CVS Courtroom?
I was an infusion pharmacist.
Okay. What does that mean?
There are patients that come out of the hospital that have to finish IV intravenous therapy at home. We coordinate that, supply the medications, and dispense them for them.
Okay, very good. And I'm assuming you are ready. You were registered with the state of Florida.
Correct.
Okay, and are you still licensed, or is it you let
I
that
am not.
lapse? Okay. Where did you get your training to be a pharmacist, sir?
I graduated from the University of Mississippi in 1981.
Okay. And how long were you with Courtroom?
About 10 years, a little over.
Okay. During the course of your tenure with Courtroom, did you work with Beata Kowalski?
She was an infusion nurse for Courtroom, yes. As far as working with her, no, I can't say that I did.
Okay. You came in contact with her on the job occasionally?
Well, they were out in the field. I was always in the branch.
I see. Was there a point in time at which you became involved with dispensing medication for Ms. Kowalski's daughter, Maya Kowalski?
Yes.
And when did that occur?
2015, November or so.
And was there a prescription that you had initially to fill for Maya Kowalski that was written by Dr. Kirkpatrick?
Yes.
And do you have that prescription with you today?
No.
Do you remember it?
Yes.
Okay. And if you would tell the jury what the prescription was for?
If it was a hydromorphone prescription, it's the first one we got.
Okay. And what is hydromorphone?
Hydromorphone is a narcotic pain reliever.
Okay. Do you remember the dosage and the route and all that stuff? Or
I remember the route, not the dosage.
Okay. Your Honor, permission to approach the plaintiff and show him.
Yes.
I'd give you my only copy.
Okay.
You can turn it over, sir, after you've refreshed your recollection.
I'm sorry?
Just turn it over when you're finished. Thank you.
Can you tell the jury what the medication was and what the route and dosage of the medication was?
Medication's hydromorphone injectable, given IV via patient-controlled analgesia. It's 0.05 milligrams as a demand dose only.
Okay. Now, is hydromorphone also known as Dilaudid?
That was the brand name when it was first introduced. It's been generic for quite a while.
Okay. And that's analgesic?
Correct.
You said did you say it was a PCA, a patient-controlled analgesic device?
Correct.
Could you explain to the jury what that entails and what that is?
Patient-controlled analgesia involves administering meds intravenously via a pump. And the patient-control part comes that they have a button on a bolus cord that they can push to give themselves an additional dose of medication.
So the patient is able to give themselves a dose of medication as they need it?
Correct.
But there's a governor, if you will, on how often they can do that?
The pump is programmed with parameters that will limit the amount of the dose and the timing.
Okay. So in other words, you can only give so many doses per hour or per day or whatever. Okay. In this particular case, how long, how much was the dosage set for Maya Kowalski?
The dose is 0.05 milligrams, Mayor.
Sure.
With a 30-minute lockout.
And
no basal rate.
I'm sorry?
There is no basal rate.
Okay. Could you explain the lockout and the basal rate, please?
A basal rate is when the patient is getting a continuous infusion at a certain level. And then what we would call a demand dose is an additional dose given to increase the analgesia.
So in this case, there was no base rate. Sorry. There was no base rate. There was just a periodic dosage.
Correct.
Okay.
That could be administered.
Okay. And what was the date of the prescription that you got?
November 5 of 2015.
Okay. And did you fill that prescription?
Yes.
You dispensed the medication and the device?
Yes.
Okay. Were there subsequent prescriptions for the Kowalskis involving the medication ketamine?
The Kowalskis, I believe, had gone to Mexico for a ketamine coma. We did not get a prescription back until the following year.
Okay. So, in other words, you get some prescriptions in 2016, not 2015.
Correct.
Could we show Defense Exhibit 3402A, pages 1 and 2, please?
Inquiring Mind says, I love seeing this judge take ownership of his court.
Does that refresh your recollection of the hydromorphone prescriptions are at the top there, but there are several ketamine prescriptions below that.
Yeah, this is chronological order.
Yes, sir.
And the first ketamine is not until February 25 of 2016.
Okay. And then, and could you tell us how much ketamine was dispensed and for what dosage?
The dose is 50 milligrams orally as needed for RSD pain flare.
Okay. And it looks as if you dispensed that on February 25th initially, correct?
I don't recall dispensing it. You'd have to look at the dispensing record to see if I was the actual pharmacist on there, but I don't recall that.
Okay. This document that we're looking at, is that a document from Courtroom?
Looks like Courtroom's medication profile.
And what is that?
It's a list of the medications we dispensed.
Okay. So this, in other words, does this document indicate that Courtroom, somebody at Courtroom, not necessarily you, dispensed the medications that are listed on here?
Yes.
On the dates indicated?
Yes.
Okay. And the same is true of page 2, second page of this?
Yes.
I don't know how he remembers what prescription he filled back in 2016.
If I could refer you to the, what did you call this? Prescription profile?
Medication profile.
Medication profile, sorry. On the second page, the description of the dispensation on May 20th, 2016. How many bottles were dispensed?
6.
And each bottle contained what?
I think they were 10 ml bottles. I am not positive.
Okay.
They could have been 5.
Okay. And is that true of the dispensation on June 24th?
Yes.
And then the others are smaller amounts, correct?
That's a specific dose. I don't think that indicates what we dispensed.
Okay.
The 0.5 mils would be equivalent to the 50 milligrams dose ordered. I don't think we dispensed one dose.
I see.
If you flip back to page 1, you can see what the header is for that column.
RX number, medication.
Yeah, unit of measure. Okay. I can't tell you what we dispensed.
Okay.
Wow.
But the prescription looks like it's 100 milligrams, 100 milliliters, 50 milligrams PO BID.
That's the concentration of the medication in a 1 milliliter volume.
Okay. And the PO means per oral, and the
correct
BID is twice a day.
Correct.
I can't tell you what we dispensed. That's ringing around in the jurors' heads right now. I can't tell you what we dispensed.
If I could retrieve that.
Absolutely.
Laura says, "Don't think Mr. Hunter feels good. Saw him grimacing a couple days ago. If you hurt, you aren't going to be cheerful." I think he has some help.
That is all I have. Thank you, sir.
Mr. Anderson.
Mr. Schott, were you aware, or are you aware that this was dispensed, the hydromorphone was dispensed immediately before a trip to Mexico?
I am now.
Okay. I'm going to refresh your recollection if I showed you your deposition of, what date is it? October 22nd, 2019, a little earlier than this.
On what date?
It says October 22nd, 2019.
Oh, the deposition date, okay.
Yes. May I approach him?
You may.
Mr. Hunter has at times been, the judge has told him he can remain seated for an argument. So the judge is aware that Mr. Hunter is in pain or in some state of discomfort or something. And that's personal to Mr. Hunter, so we can't speculate on that, but we are aware that that's going on. K-Cat, the fact that he says, I can't testify, I don't know, I can't tell you what we dispensed.
I'm really only interested in the
Okay.
question and answer. Does that refresh your recollection about knowing this was about Maya's treatment in Mexico?
A little.
Okay. That's all I have.
Mr. Hunter, do you have any further questions? Members of the jury, do any of you have any questions?
Yep. Okay, the jury actually might recover some ground for either side at this point. With this educated jury, with their knowledge about medicine, especially the ones who are in the nursing field, the questions could actually make it more of a win than they have already for the defense, because this one fell on its face. They wanted him to be able to testify to what was dispensed, and he literally admitted he could not, and that was no further questions. So it turned into nothing. And I think even the defense, when they were given the option of choosing two documents, whether they could bring in the script or whether they could bring in these records, they went with the records. And because he can't authenticate them, I think it was a loss. They would have been better with the script. I think that would have been better off for them. But yeah, they gambled and they lost on that one. Man, that's okay. Jury questions incoming. Doesn't look like there are very many. Probably from one or two witnesses, maybe possibly three. Jules will let us know at the end of the day. This guy is subpoenaed. Yes, he was a pharmacist. Works with CVS. Casey says, all right, I'm 99.9% certain that juror number 6 is a nurse case manager based on questions. She would be experienced in bedside nursing along with diagnosis codes. Amazing juror. Casey, or Cassie? Or Casey, I'm sorry. I think it's Cassie. Thank you very much. Yeah, we definitely have somebody who's got some medical experience there, number 6. Jenna says, hydromorphone is life-saving for us with massive chronic pain. I've had it for my PE and MS. It's time to release, so one pill lasts for 8 hours. Very safe when taken correctly. Nurse Elise says, I like this witness. It's very honest. He definitely comes across as believable, and also at the same time makes you wonder why he's here. What was I supposed to gather from that? I can't get over the fact that the defense gambled on. The judge gave them one of two documents, and I think they chose poorly, and they ended up with nothing. And then their own witness fell flat. I don't know if this was just a matter of not prepping the witness and not knowing the answers. You're not a lawyer generally doesn't ask a question they don't know an answer to, right? Occasionally you hear Mr. Whitney say this, usually in a proffer, when he'll say, "Hey, I don't know the answer to this one," and he'll ask a question. All the other questions he knows the answer to. He knows what they're going to say. They've said it before in a deposition. He knows what the evidence is. Occasionally he'll ask a question, usually in a proffer. But here, Mr. Hunter asked the questions of this guy, and he's like, I can't attest to that. That just shows dosage. We wouldn't have the numbers there. That's not how we would have dispensed that. It could have been half the size of what it says, and I can't tell you what was dispensed. And that was just, it was like getting the rug yanked out from under you. After all that fighting, too, after all that argument and agreements on what to redact and everything else, and they ended up, the little bit they got is worthless to them. Clinic's fun for Shapiro. We give him a hard time. I really, really like Mr. Shapiro. I like his passion. I like his zest for doing what he does. I think he honestly loves being a lawyer, and he gets carried away a little bit, and sometimes his enthusiasm carries him into dangerous territory, and we've seen him there several times. Sometimes he's had to back up with hat in hand and apologize to the court and beg forgiveness. But that just makes me like him more. Sunflower Day says, I don't like his sneakiness. Hey, this is a battle, okay? You can't. There are rules that you have to share a lot of information, discovery, that you can't just surprise the other side with this gotcha stuff right there in court with no warning. There's a lot that has to be shared, but within those rules, there's room for maneuvering. There's strategy in the order you call things, and you still have a lot of skill involved and strategy involved in pulling off a court presentation to get your side to be selected as the winner by the jury. I love it. I love this game. If only it didn't involve the feelings and real people whose lives got crushed or devastated or completely turned on end. I was telling Rob I could watch this. It's like watching NASCAR, but just for the wrecks, but with nobody getting injured. I'd love it if I could watch this without those, the fact that we've got real people whose lives are on the line here that are getting argued over. Let's see. Can I just give chat some advice? If you or your loved ones ever get an injury, please don't let it go without treatment. This is exactly how CRPS starts, by an injury that goes untreated. Goodman Law says, Nicole says, generally there are no surprises in lawsuits. Tactics is one thing. Surprises is another. Yeah, when there is a surprise, that's when you see adamant objections. And you'll hear from Cruels, Miss Cruels, you'll hear her say, Your Honor, they just gave this to us last night. And everyone's like, hey, she's whining, she's complaining. No, she's got a valid argument. They need to have time to prepare their side of every story. And if something's presented at the last minute, and we've heard it from Mr. Whitney as well, saying, hey, we need to know in advance. You've got to tell us this. Who are you going to call? What are you going to use this for? There has to be some notice back and forth. So it seems whiny, but that's the game, and that's how it's played. Good points, all of you. Christy, I'm not sure if I thought I welcomed you already. Welcome to the gallery. I think your new member notice is stuck on my screen forever. Sometimes they get stuck up there, so I might welcome you 3 or 4 times. It doesn't clear off after I show it. But welcome again. Good to have you here, Christy. Wondering if Beatty is still going to testify. Auntie, I think they are definitely going to call Beatty. I think they will. That's going to be on Monday. Just doing the math, because some of you were asking, at the beginning of trial today, the plaintiff had 3 hours and 40 minutes left. And they've used, Mr. Anderson used about 20 minutes on cross with Dr. McCain. Mr. Whitney, when it came to crossing Jason Baker, used about 10 minutes. We had several jury questions, which uses a fair amount. I think we could probably safely say that another 10 minutes was assigned to the plaintiff for that, which would mean that they've burned through those 40 minutes and are sitting right around the 3-hour mark for the remainder of trial. And they have everything that happens today with the depots that are being played. I know that they've cut down a lot of their designations on those depots, so it'll sound like mostly evidence or testimony in those depots that's favorable to the defense, because you won't hear much cross. Generally, that's how it works. Not always, but generally. And then they have to save time for Miss Betty. Kathy Betty has to be priority. Emma Daisy says, as much as I dislike the defense team, I don't wish ill on them. They're doing their job. Even murderers have a lawyer to advocate for them in a criminal case. This is a civil case. Yep. Jennifer Cochran-Fent says, just a thought. Why would insurance be 100% responsible for a bill with patient held in shelter? I understand she was receiving treatment, but could have been outpatient. He was able to DC days after mom died. the question about the insurance being responsible, I'm not an insurance billing expert, so I don't know. Maybe if someone in chat could answer this one specifically, I'd love to.
One of the questions I'm not going to be able to ask, unfortunately, and the other one, sir, the first ketamine was issued with a stop date, and the next treatment was issued before the stop date was concluded. What does that mean? And if we need to put the exhibit up, we can. Can we put the exhibit up? Or I can just hand them the sheet of paper. Okay.
The jury's catching everything.
Am I on?
Yes, sir. You can answer the question.
We received a new prescription with a different dose. So when we dispensed the first or the second prescription for the first time, we canceled out the old one. So there were not two prescriptions on file at the same time.
It's even worse for the defense.
Mr. Hunter, any follow-up questions? Mr.
It's getting
Anderson,
worse.
any follow-up? Okay. May this witness be excused from all subpoenas?
That to me sounded like, this report is
Thank you,
duplicate.
sir.
It doubles
Thank
up.
you for being here.
Actually, only one of those would be valid. Oh man. Oh. Rob says even when they say I don't know the answer,
This time, Judge, will play the deposition.
they're just playing for
Dr. Hannah.
the witness, the judge, or jury, depending on the need.
And do we know how long this one's going to?
It's not very long. I think
had me
it's
fooled.
25 minutes total.
Okay, the jury's saying keep going, right? And don't turn the lights off.
36 minutes total.
36 minutes.
And it's 2 volumes with a break, correct? There'll be a break and there's 2 volumes?
Well, it's 2 different depositions, so there might be a pause, and then it'll continue again, correct?
36 minutes, 30 seconds. We'll leave the lights on and roll tape.
Will you raise your right hand, please, Dr. Hannah? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you please state your name and professional address for the record, please?
Ashraf Hanna, 2250 Drew Street, Clearwater, Florida.
I'm not sure what address he's given.
In your experience, if you don't have privileges at a hospital, can you see a patient and consult with a patient at that hospital?
No.
And why is that?
I don't have privilege.
Okay, so you never had privileges at Johns Hopkins?
I never. Why will I have that? It's far away from me. I don't deal with patients there.
To your knowledge, Maya Kowalski's primary care physician, Dr. Wassener, never referred Maya Kowalski to you?
Again, I can't remember. When I have it here on the referral, I have it blank. I just looked at it before the depot, who referred her, and I looked, it was blank. But a lot of times, the patient herself, or the family will request from the primary care a referral to me if the insurance or if they require that. So they will go ask the doctor, please, we need a referral to Dr. Hannah. But it's not the doctor who suggested, it's the patients or family who suggested that based on their online research.
So you've been doing the IV ketamine for 10 to 12 years, I think you said?
I believe so.
And is that why you have a website that's ivketamine.com?
Correct.
And you posted some blog entries on that website?
Correct.
And I also understand you have another website called nopainhana.com, correct?
That's correct.
Did you talk to the psychologist at all in 2016 to get an idea of how Maya was doing from a psychological standpoint?
No, I did not.
Now, when you were infusing Maya, can you explain to me what type of monitoring was going on?
Well, we have EKG monitoring and pulse oximetry monitoring.
And why did you have to do that?
That's standard of care. She will show me videos of her jumping in the pool, doing activities, being with her friends and family. So she had some good response, and treatment of ketamine has been successful for her.
So I guess my question is, doctor, at what point would you determine with a patient like Maya Kowalski, okay, there's been this uptake regulation, it's gone too far, we need to stop it and go backwards?
If her condition improves or her vitals becomes unstable.
Okay.
Or if there is any change in liver enzymes. And then all along this time, I monitored, I did like 16 or 20 liver enzymes, and they were all perfect.
What about abdominal pain? Can ketamine cause severe abdominal pain?
That's from the cholangitis from the liver.
Okay, so you sent her to Johns Hopkins Children's Hospital?
Yes.
Why?
Because I failed to help her. There's nothing I could do. I told the mother, that's the maximum I can do. I cannot give her any more. She has abdominal pain. I need her to go to a bigger place. They can maybe do some continuous infusion. First of all, we need to see why she's having abdominal pain. They can do some lab work, check, make sure nothing else is going on. If I couldn't control her with my average capability, with the maximum infusions I could do here, then it was time for me to send her to another facility.
So is it fair to say that October 6, 2016, which was your last infusion date with her, that was the maximum that you felt comfortable with?
Yes.
Who gave the order to have a port placed?
Yes.
Who did?
I did.
Well, then let me draw your attention to your last infusion here, October 6, 2016. That can be found at HANA 000184 to 185. And the patient on that day is in 10 out of 10 pain still, with pain medications. And you now went up to 1,250 milligrams plus a 50 milligram ketamine bolus, and you did this infusion over a shorter period of time, 2 hours, which gets us to above 24 milligrams per kilogram per hour. What was the medical decision making about going up even higher on 10/6/16?
As you see, the day before she came with 10 over 10. She was screaming. She was crying from pain. Her mother stated that I cannot live. You know, she's in so much pain. She's screaming. She's up all night. This is the patient I'm having in front of me. I did everything I could the day before. I discussed with the mother. We said, okay, you know, actually the father was there, you know, and I discussed the case with him. You know, I said, I'm really running out of option here, probably. You know, I can try to shock her a bit more, try to give her, you know, I don't want to give her more dosing, but let's see if I give it to her in a shorter period of time that you can achieve a better result. And that was, you know, I told him, this is the maximum I can do. If she does not get better after that, we're going to send her to the hospital.
So I think you just answered one of my previous questions. October 6, 2016, that was the maximum level you felt comfortable with, above 24 milligrams per kilograms per hour?
I had given her enough. She was not responding. There was nothing else I could do.
Is it possible, doctor, that the abdominal pain you're referencing was caused by these infusions?
I mean, it can be a side effect. As I said, it can be a side effect from, you know, like a cholangitis or something. That's why we needed her to go to the hospital, maybe get liver function. And I don't know how her liver functions. And these are, as I said, reversible. So when I have a patient like that, you know, I send them to the hospital. That would be the prudent thing to do.
Over the course that you were doing these infusions, doctor, and I have 55 infusions here ranging from early January to October 6th of 2016. I also understand that you wrote several prescriptions for oral ketamine to be used at home. Do you remember doing that?
Yes.
It appears to have been signed by Beata Kowalski, an individual by the name of Joanna Misic, RN, a Heather Bonilla, LPN, and yourself, Dr. Ashraf Khanna, MD. Doctor, do you remember circumstances of providing this agreement to Mrs. Kowalski?
Yes.
What?
I'm with you, Judge.
What? What just happened?
We're good, Jeff. Okay.
Why did you make her sign this after having prescribed oral ketamine for the better part of 8 months?
So she did ask me.
You thought you were a success.
Absolutely. We had the year that I kept her in somehow improved quality of life. You know, during the years, she had better pain relief. Her pain went up, you know, to about 3 or 4, went up to 8 or 9 on several occasions. She was able to do more activity with her family. I consider that a success.
She had a severe flare that took her down to a 0 quality of life after 55 infusions with you over the course of 8 months, and you're going to tell the jury that's a success?
Well, you have to look into the duration that she did good. There was a lot of time she didn't improve. She had a flare. She had a downside. Any doctor, you talk to any CRPS expert, will tell you that CRPS has ups and downs. And then if she got an injury, if she got anything that did hurt her more, trauma to anything, her pain can be significantly severe. And then if she had some abdominal discomfort, for whatever reason, that can flare up her CRPS and can prevent her from getting better with infusion. That's why I send her to the hospital. It happens with few patients. They go to the hospital, abdominal symptoms improve, and then patient slowly starts to improve. This is very common. You have not seen CRPS patients, sir. You have not treated CRPS patients. I've treated 18,000 CRPS, infusion done with thousands of patients that are treated for me that coming from all over the world. So, and I've seen that very common.
So she comes to you with a quality of life scale in January of 2016 of 2, and when she leaves you, it's 0, and you're now sending her to the emergency room at a children's hospital, and that's considered a success in your book based on 18,000 patients.
Sir, the treatment, she had a flare. All those patients that I've treated, at some points or the other, they had 0 relief. At some points or the other, they have trauma that increased their pain. They had surgery, and their pain went sky high, went to 0. Then we treat them, and then they get better. That is not, the treatment didn't end. They ended it. Things ended it this way. But that doesn't mean treatment was not a success. The fact that at some point her pain went to 0 doesn't mean that ketamine failed. Ketamine has provided her with a good quality of relief, better than what she was on. That's documented by her family, by videos, by everybody. That's number 1. Number 2, the fact that if it was a 0, doesn't mean that it failed. It means she had a flare-up. So you keep saying it failed, she ended up with 0. She didn't end up. I just sent her to the hospital. I send patients to the hospital every now and then. That doesn't mean they're failed. They go to the hospital, they get treatment, and then they come back. And we continue the treatments. I have several patients like that.
Didn't you testify, though, that you had reached your maximum amount of ketamine that you felt comfortable with?
At that time, sir. That's why I sent her to the hospital.
When Maya Kowalski went to the emergency room at Johns Hopkins All Children's Hospital on October 7, 2016, my understanding is your office was contacted by the emergency room. Do you know anything about that?
Correct.
Do you know what you told the emergency room you were doing in terms of infusions?
Yes.
What did you tell them?
I was telling them she was getting infusion of IV ketamine at our place, and she was having, diffuse pain, abdominal pain. We failed to really treat her, and I wanted to see if there's anything else going on to do some investigations for her.
Would you consider having to send Maya Kowalski to a children's hospital on October 7, 2016 to be a complication?
It was a side effect. I did not know why she is having more pain. I failed to treat her. During that day, I failed to help her. So there was nothing else I personally can do for her. And I want to make sure there's no other underlying condition that I'm missing.
When Maya presented to Johns Hopkins on October 7, 2016, she indicated to staff that she had not eaten in 5 days. In your experience, patients that are having high-dose ketamine infusions, can that create issues with eating?
It can, but I believe the mother was giving her IV fluid. And I wasn't aware. I was not aware that she was not eating for 5 days.
If you were aware of that, would that have changed your ketamine treatment approach in the last few days you were with her?
Yeah, I will probably hold it and have her take a break so she can eat.
Okay. Is there an association between ketamine use and having trouble with eating?
I mean, ketamine is like any other medication, can cause nausea.
Did you ask Maya how often she'd been eating?
I personally did not. Yeah.
Now, before this visit, doctor, you attempted to go to Johns Hopkins to assess Maya at Johns Hopkins, correct?
Correct.
And you drove there, right?
Correct.
And you were told you couldn't visit Maya because you'd never applied for emergency privileges, right?
Yeah, because initially I got approval. I applied for something, I can't remember. You know, I remember signing whatever they needed me to sign. I remember the judge said that I can go see her. Again, that's my recollection. Don't hold me on that. My recollection, the judge did approve me going. They sent me some paperwork to sign. I signed it, filled everything. And then when I went, they declined me seeing her.
So June 7, 2017 was the next time you saw her?
Yeah, in June 7.
Oh, that's all approximately 5 months after you saw her in January of 2017, correct?
Correct.
And I'm asking you, Dr. Hanna, if you could tell me, based on your record, how much relief you documented the patient had since January of 2017.
Yeah, so 60 to 70% improved. You know, she did not have hypersensitivity or allodynia.
Was she on ketamine during the period of time from January to the time she saw you?
No.
Do you know what she was doing in that interval of time that led to a 60 to 70% relief?
No, I mean, I believe she was doing some therapy.
Okay. And I think it says here she was doing physical therapy, home exercise program, aqua therapy, correct? Let me ask you this, doctor. Within a reasonable degree of medical probability, do you think that the 60 to 70% relief that you noted here on June 7, 2017 was due to the ketamine that you administered back in October of 2016?
It can be. There's a very good probability that it can be. Yes.
More likely than not?
More likely than not, because she tried it before the ketamine and it did not help her. She had tried the therapy before the ketamine. The only reason why she went for ketamine is because she failed therapy. She went to hospitals. She went up north. They did put her in rehab. She went to rehab in many hospitals before. That actually increased her pain. If you look into the note, she did therapy that made her pain worse. And that's documented in all her history.
With regard to the handoff of Maya's ketamine treatment to you from either Dr. Kirkpatrick or Dr. Cantu, in other words, when you picked up her care and started to manage her care, did you get Dr. Kirkpatrick's records?
Yes.
You did? Okay.
Yes.
Did you get Dr. Wassenauer's records ever?
Dr. who?
Wassenauer, her primary care physician.
No.
Okay. Did you ever speak with him?
I don't recall.
Is that the? Oh, that's the first one. Okay.
This is intermission.
Moving to the second clip.
Doctor, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
My understanding is we were sent in response to a subpoena some standing orders from your practice for ketamine. Are you familiar with what I'm talking about?
Show me.
Yeah, I'll screen share them for you. This will be exhibit 1 to this deposition today. And this, for the record, is a...
They said, take this down. These documents are not in evidence.
Can we approach real quick?
Judge is frustrated about this. So many times these depots have done this. I think, this is the third time, maybe fourth time, that a deposition usually a Zoom deposition has included a screenshot or a split screen with the document that has not been admitted into evidence. You heard Mr. Whitney say, hey, can you take this down? And they did promptly. They promptly took it down.
Everything okay now?
It's going to have a notepad window over the top of it.
A ketamine standing order that was produced pursuant to a subpoena from Florida Spine Institute. Can you confirm with me, Dr. Anna, that those are your standard initial and maintenance therapy doses for CRPS patients receiving ketamine?
Yeah, but again, these are, as you see here, dosage may left up to MD discretion. So they change a lot, yes.
Understood. But your standard initial dose is 1 milligram per kilogram per hour?
Yeah, those are guidelines in general. Yes, I start with the 1 milligram per kilo and titrate it. I can stay at 1, I can stay at 2, I can go to 3. It really varies.
And how often do you go above 20 milligrams per kilogram per hour in your practice?
Not that common.
How did you come to gather from Dr. Cantu that was what happened in Mexico?
Personal phone call.
All right, let me ask you this. Where in your chart is there a statement from a psychiatrist clearing Maya Kowalski for ketamine treatments and ruling out underlying issues of schizophrenia?
Well, I know that Maya was seeing a psychiatrist, prior to that. And also with Maya, it was a different situation because this is usually for fresh patients who did not get ketamine before. Maya did see Dr. Kirkpatrick in Tampa, and she did have ketamine. And Kirkpatrick, also, he does require psychiatric clearance. And then she saw Dr. Cantu, so she already had IV ketamine before, and without any problem or any flare-up of any schizophrenia. And there was no mention of any of the notes that she had schizophrenia.
So you were relying on Dr. Kirkpatrick about a psychiatric referral?
Yeah, and the fact that he did clear her for ketamine infusion.
Okay, but I'm not able to see, there's no record that Maya Kowalski ever saw a psychiatrist for clearance with Dr. Kirkpatrick. Were you aware of that?
I know she was seeing a psychiatrist or psychologist, that he was aware that she's getting ketamine infusion.
Okay, so what psychiatrist was Maya seeing, doctor?
I cannot remember, the name. I know she was seeing either a psychiatrist or a psychologist, in the past. I know she was following with one, and I know that she was cleared to get ketamine. At least Dr. Kirkpatrick felt comfortable giving her ketamine infusion. And if Dr. Kirkpatrick felt comfortable, I felt comfortable.
All right. So do you require a psychologist or a psychiatrist?
Either or.
Do you anticipate doing so at trial, if asked?
I don't know. I mean, if the judge asks me or you ask me, I may have to review that. I haven't reviewed it. I don't know anything about that. This is all new to me now.
In other words,
most of what I have been asked is regarding my treatment to Maya so far.
Let me ask you this, doctor. Do you recall referring Maya Kowalski for implantation of a infusoport to facilitate ketamine infusions?
I mean, I do. Can I answer?
Oh, sure.
Yeah. I mean, I do recall that we needed, a port for her. Yes.
Did you recall discussing that referral with the surgeon who placed that port?
Okay, I cannot recall. You're talking about 5 years ago. But I recall that, because of Maya's condition, her difficult IVs, and the frequency of getting the infusion due to her intractable pain, that we did suggest, getting a port. But because I do not manage the port, I believe sometimes the order has to come from the doctor who's going to manage it. So it has to be primary care or surgeons or something. But we did make a recommendation, for a port because obviously we don't want to torture, a young girl with IVs all the time, especially with patients with CRPS. It's very painful to restart IVs for her.
Is it your customary practice to speak with the surgeon who will be placing that port?
Not really. Not usually.
What I'm trying to drive at here, Dr. Hanna, is would you have discussed your treatment protocol with the surgeon who placed the port prior to the port being placed?
Probably no. I don't usually do that.
Okay. So, doctor, what is a caudal block?
Okay, a caudal block is basically, like an epidural injection, and it's done in the tailbone. And basically with her, it will be like a lidocaine, putting in lidocaine or bupivacaine, a local anesthetic to produce a block, a saddle block, or, just basically something to block the pain signals that are coming from her legs to her brain and spinal cord.
Had you ever done a caudal block on Maya Kowalski?
I don't recall.
What was the longest infusion that you did with Maya Kowalski?
I believe 4 hours.
Okay. If I can't find in your chart where there was a scheduled visit for this.
Maybe it was just a conversation, but we actually didn't schedule her.
Okay. Well, can you take a look at your record if you have access to it and see where your list of schedules are and tell me if you had a scheduled appointment with Maya Kowalski for Monday, October 10th of 2016 or Tuesday, October 11th of 2016?
October what?
October 10th or October 11th?
I have October 10th. Okay, so these, I believe, were dates, and again, I don't know, they were just on the schedule. They can be from before. It really cannot tell me when were they scheduled, okay, whether the day before or the month before or whatever, because, Beata, with Maya, we used to schedule them monthly or whatever, so to be able to make sure that we have a place for them on the schedule. So, but I have here 10-10.
So you have a 10-10 patient cancellation or no-show for Maya Kowalski, 10-10 of 2016?
Yes.
What about 10-11?
Yes.
You have a 10-11 no-show and cancellation?
Yes.
What services had you envisioned rendering based on your documentation on 10-10 or 10-11?
Nothing documented. And she really didn't have any clue about ketamine infusion. She had no idea about even the diagnosis of CRPS. She didn't know really too much about it.
Okay, and what led you to that conclusion?
I had a conversation with her. I had to explain to her.
Didn't you also have some conversations with doctors at Johns Hopkins Children's Hospital?
Yes.
Do you recall how Dr. Sally Smith introduced herself to you?
I can't remember.
Have you ever applied for privileges at Johns Hopkins Children's Hospital, doctor?
Actually, I may have. I think I remember they did ask me because they wanted me to come, and initially they want me to come and evaluate her, over there. So, or to see her. I think they wanted me, in order for me to see her over there, they want me to apply for privilege. I think so.
And did you apply?
I can't remember, honestly, the detail of that event.
But
I remember that they allowed me to see her. That's what I recall. I recall that they approved me seeing her. They sent a letter of approval, something like that. And I went there. And when I went there, they declined me from seeing her.
Who approved you?
I don't know. I got the morning approval to see her and to go there. And then I went that evening after office hours to go see them. And they declined me from seeing them.
Why were you declined?
I have no idea.
Was it because you didn't have emergency staff privileges?
Again, they didn't even want me to see her as a visitor.
How common is it for you to have a patient where you do 4-hour infusions, then you shorten it to 3 hours, and then you shorten it to 2, and then you go up to 8 hours?
It happens. I had a patient from every patient is different. I had, again, 4 to 3 to 2. That's not a major difference. The doses have not changed a lot. I just wanted to get a higher peak concentration in her blood. And as I said, Maya's base was already 1,000 milligram over 2.5 hours. So she had that before.
I guess my question is, I believe you reviewed Dr. Kirkpatrick's records before beginning ketamine therapy with Maya, correct?
Correct.
But you didn't review any records from Dr. Cantu?
No, I did talk to him. Before I infused Maya, I did talk personally to Dr. Cantu.
And how long was that conversation?
Probably at least half hour.
And when you communicate with patients or their families via email, do you typically save those emails in your chart?
Usually, yes.
Why is it?
I mean, yes. I mean, yeah, typically they should be in the chart.
And why is it there are several emails between you and Beata Kowalski and others that never made their way into your medical chart for Maya Kowalski?
I don't recall.
Some of those Gmail accounts made their way into the chart and some did not. I'm trying to get an idea why it is that some Gmail emails made their way into the chart and some didn't.
I don't know.
Dr. Hanna, I've screen shared something from your chart with you. Can you see that?
Yes.
And it's going to be an exhibit. So it's Hanna 001753. What is it that we're looking at here?
It's a prescription that says it's medically necessary for Mediport placement for frequent infusion therapy.
Okay. Is that the type of prescription that you would author in the event that you want one of your patients to have port placed?
Yeah, so it's not an order, it's a request.
Okay. Do you know who ordered the port for Maya Kowalski in this case?
Again, I don't know. I mean, either primary care or the surgeon. I mean, if the surgeon evaluates her, then the surgeon will put it in, so I'm not sure exactly, how that works as far as orders or whatever. But, we usually request, and then usually either the primary care or the surgeon will help with the maintenance of the port.
Okay. So is it fair to say you recommended placement of this Mediport, and then from there you didn't have any further involvement with the port?
Correct.
Dr. Hanna, I'm Greg Anderson, Maya Kowalski's attorney in this case. You were the, can we pin Dr. Hanna? There you go. Were you Maya's attending physician during 2016?
That's correct.
And you were responsible in part for her pain management?
Correct.
Your responsibilities then would be to take all reasonable and safe steps to alleviate her pain and improve her living condition?
That's correct.
The amount of ketamine that she received, based upon your background, training, and experience, review of the literature at that time, and experience clinically, did they support the treatments that you gave?
That's
so if this is playback, can you say that again? So
that's correct. That's correct.
All right. And the at no time was Maya ever in any danger from the medication that she received from you?
Absolutely not. All the record shows she's been extremely stable during the infusion.
And did you take liver studies from her before and after her infusions?
Yes, multiple occasions.
Is that one of the key ways to determine whether she is having any negative effects from a ketamine infusion?
Correct.
And did she have any change in her liver functions or any of your other blood work indicative of any side effects, detrimental things occurring because of the ketamine infusions?
No, sir.
During the time that you had Maya as a patient, did you have the opportunity to meet and get to know Beata Kowalski?
Correct.
Tell us all of the doctors you can recall speaking with about Maya's condition before or during her treatment.
Oh, I remember talk to, Dr. Cantu and Dr. Kirkpatrick.
And the treatments that you had for Maya, had they worked in the past for this child?
Yes.
So she received relief? Yeah.
Yes.
And so tell the jury, if you will, about titrating. They may not know that term. I certainly didn't know it when I first heard it. But insofar as the administration of ketamine, what does titrate mean?
Titrate means you adjust the dose based on effect and side effects.
Okay. And so are you monitoring Maya's, lack of a better term, vitals and responses to the ketamine as she is receiving it?
Absolutely.
Based on your background, training, experience, and consultation with the other pain management physicians, was this medically necessary in order to keep her CRPS pain under control?
Yes.
And CRPS pain, can you describe to the jury, I know it's difficult, but in terms of ranking the pain from patients who are in the midst of a CRPS episode, outbreak, whatever you'd like to call it, can you give the jury an idea of the severity of it?
CRPS pain is the worst possible pain, described by, patients who had kidney stones and patients who had labor, patients who had all kinds of pain, that this is far worse pain than any pain they ever experienced.
You guys, no more personal attacks, please.
The number one cause of
we don't do that
suicide from a chronic pain condition.
Understanding that your specialty is in pain management, but how long have you been a licensed physician in the state of Florida?
Since 1996.
What is your specialty? Do you have any other specialties besides pain management? I mean, are you an anesthesiologist or neurologist?
I am board certified anesthesiologist, board certified pain management.
So, and how long have you been board certified?
Over 25 years now.
And Beata Kowalski, was she, from your experience with her, a concerned, attentive mother?
Yes.
How's Maya doing today, to the best of your knowledge?
To the best of my knowledge, she gets some flare-ups, and I believe she's an A+ student.
Okay. Do you know when the last time she had ketamine was?
Was the date she was sent to the hospital.
Do you know what Maya Kowalski's weight was as expressed in kilograms during the entirety of the 55 infusion sessions she did with you?
I believe it was 27.
Does that complete the plan?
Yes.
Can I see the attorneys for just a second?
Yes.
Okay, guys, I know we've got a lot of new people here, and I will say welcome. I appreciate you guys coming in and spending some time with us. Just want to reiterate that we are respectful here. If there's somebody out there that has an opinion that you don't share, we don't need to attack each other over it. Let's listen to each other's opinions, and we can agree to disagree. But please, no personal attacks, no attacks on the witnesses, appearances, the names, anything like that. We can do better than that.
Okay, members of the jury, we're going to take an afternoon break. This is going to be a very healthy break. It's going to be about 20 minutes long. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All right. 10 minutes long. Sounds like we have some business to attend to. Nick, you're absolutely right. The judge has been talking to the attorneys a lot today, frequently with tone. We'll discuss a little bit. Let's see. Were they going to bring up the fact that some documents got shown that shouldn't be? That was a little bit of a problem. We saw the notepad being opened up on the computer that was sharing the Zoom recording. That's how they've been resolving the issues when there's a document on screen that has not been admitted to evidence.
I'm going to talk at sidebar with the attorneys for a few minutes. You're welcome to continue to stay and listen in, but I am going to have the sidebar machine going on. So if you want to walk out for a break, you can. If you want to sit here, that's fine as well.
Ooh, this is rare. So he says the sidebar machine going on. That means the jurors have left. The judge has called the lawyers up with the white. Oh, it's giving homework. Mr. Anderson's looking at how thick it is. So they each got handed a ream of paper. Something about the clerk. There's no audio on the machine. I'm just checking. It sounds like they have white noise going in the courtroom, so I'm not going to hear anything. I just wanted to confirm that. But they each got handed a ream of paper, and we don't know why. Everyone gets homework, apparently. Mr. Whitney has his behind his back. Judge is the one doing all the talking right now. Mr. Shapiro wants one for himself. He's looking over the shoulder at Mr. Hunter's copy. Mr. Hughes is just completely left out. He's looking over Mr. Shapiro's shoulder. Judge says this will take 20 minutes. 20 minutes. Wow. Chevron says, I thought this helped the plaintiffs. There's definitely some stuff that would help both sides in this, and that's what happens with the designation. There's a deposition, and some of the answers are good for defense, and some might be good for the plaintiffs. Each side gets to specify which parts they want played. So we don't know until the end of the day, or maybe right now, the lawyers might be telling the judge, or might tell the judge shortly, how much of that deposition to assign to each side based on the designations they wanted played. So, let's see, judge hands me that. I'm not looking over shoulders. I'm looking for an exit, says Rob. That's a lot of homework. Everybody gets a copy. I'm trying to think what would be that thick. That's like a ream of paper. We're talking hundreds of pages. I don't know. This is, caption this, says Betty B. Caption this. Marmar says, R.A., do you ever feel like a sports commentator? Like for a quiet sport like golf? Because you remind me of one sometimes. I have that quiet, dry voice. Mr. Whitney lines up to the tee. The crowd is hushed. Slight wind this morning. No, I don't think I could do golf commentary. First of all, my golf experience is limited to miniature golf courses. I have yet to be able to. The only thing I could do with a golf club, like an actual golf club, is I can take an 8-iron and I can walk around bouncing the golf ball on the head of the 8-iron. I don't know why I have that skill. Yet as soon as I start swinging the club, I can't hit the ball. So I'm no good at golf at all. But, well, we're just going to have to speculate here on what's going on, or I guess we can just sit here and not know. But the judge has handed out a lot of papers to everybody, and everyone has some reading to do. Don't think these are jury instructions. I mean, they could be. Lacey Ann, thank you for the super chat. I appreciate that. Keep it up. Love the sticker. Crusoe says, I can only use a golf club as a weapon. I cannot condone that. Could that be in the exhibition lists? Also, I think it helped the prosecution. Brooke, talking about the last witness, I think they got some good stuff out of that. You've got testimony that there was a very high dosage of ketamine given, that the doctor who was very... Mr. Anderson is eating his copy. Sorry, I just noticed. you've got testimony that this very high dosage of, well, first of all, the ketamine was like taper, and then shot back up at the last time, and then they're like, go to the hospital. That the doctor testifying, I did everything I could. I gave her all the max dose of ketamine I could. I even reduced the time frame in which the max dose was administered in, which basically does increase how much is in the body active at one time, at least in some part. Hang on, we've got Jules calling in. This will be good. 1 second.
Call from Jules.
Jules, can you hear me?
I can.
I can. What just happened? The judge just walked out with reams of paper to give everybody.
He's not, and I repeat, he is not in a good mood.
Okay.
He's annoyed with Hunter. I mean, big time annoyed with Hunter. I am so surprised that Hunter did not get sanctioned today.
For the face he made?
Yeah.
Yeah.
It was not pleasant. And then, what do you call it? He left the courtroom, right after the testimony was done. And, where's my, here is it. So, on the, okay, the what do you call it? The pharmacist.
Mm-hmm.
It was juror 2 and juror 12 that asked the questions. But this is the funny part. These people are really funny, Scott. They really are. The bailiff walks over to the jury box, and number 7 just throws up his hands like, "Not me this time." So it's like, so of course we all started laughing, but it was 2, which he hardly ever asked questions. So 2 asked and 12. Now we don't know the question that was asked. We don't know which juror it came from because
one was
he only asked. Yeah. So we don't know. Were you listening in? Do you know what the questions were?
No, we didn't get to hear him. He had the white noise machine on, so we couldn't hear those ones.
Oh, okay.
Yeah, we're curious as to what's going on now as well. I don't know.
Well, I don't know. I don't know because I left the courtroom because he said that he was going to be talking to the lawyers up front, and if we wanted to stay, we could stay, and it was going to,
Yeah.
But if not,
well, he's done
go,
talking. He's left the room. I don't know. They gave them a bunch of reading material, like a ream of paper each, and just sent them back to their desks. I think they're reading now, but the judge has left the room.
I think it's because of Hunter. Now, don't quote me. I will be able to find out for you, though.
I trust you will.
I will be able to find out for you, but I suspect because of how Hunter was carrying on over the meds and all of that, and Judge Carroll kept bringing up the 403 and the Chapter 39, but he kept referencing 403, 403, 403, and also he said, "I've already ruled on this," and so I'm just wondering if he's making them go over their own crap. He's not in a good mood. I will tell you that.
Well,
He's not in a good
part
mood.
of what we saw, and this was part of what led up to Mr. Hunter giving that scowl to the judge. The defense was trying to bring in a prescription history, like a list of filled prescriptions, and the judge is like, "Well, or it was that, or maybe the script." I've got fire engines going by. Sorry.
He wanted both.
They wanted
both.
And the judge is like, well, because the other day I asked if this, the medical, the script information was in, and it is, and they're like, actually, it's not. And he's like, wait, I made the decision because you told me it was, and I admitted something previously because of that, and now I'm in a bind. I think he feels like he got either lied to or tricked into admitting something, and then he would only give them one of them, and when he got it, he's like, okay, you can use the other to refresh the jurors, the witness's memory, but don't show the jurors by all means. That was. I'm trying to rewind and find that little scowl so we can look at it. Let's see. I think it's right
it wasn't. It was this. He was so angry, and also Hunter was angry at his own witness because I can't remember which question it was, but the two ketamine things. Hunter tried to get him to say, "Oh, Beata filled 2 prescriptions of this, in a month," and he's like, "No, one stopped. The dosage was changed, so one got canceled, and the other one." And Hunter was not happy. He was not happy. He thought he was going to get stuff out of him that it didn't work, in my opinion.
Yeah. Let me see if
They
I can.
better have. Yeah, you find that, but all I could say is, they said they were going to rest on Tuesday. Now they're saying they're going to rest on Wednesday. They better, in my opinion, they maybe scored 1 or 2 points on their side. I don't think that they won this jury over. So they better come up with a grand slam Monday, Tuesday, and especially Wednesday, because those jurors are going to have a 4-day break.
This is. I'm going to rewind here. Let me see what we can do. I'm trying to find the exchange that ended with Hunter getting admonished by the judge not to glare at him like that. And I'm rewinding. There's just so many faces that he's making. I'm going to need to find which one it is. But okay, the judge is still out.
Very,
so, yeah. It was the very end of the.
Yeah.
Okay. I'll find it here.
Even the what's her face, Miss Carol. I can never pronounce her name, but you know what I'm talking about.
Carol's.
She tried. Yes, thank you. She tried to shut Hunter up.
Yeah.
But he did you see where he pulled his arm away from her?
No, I missed that. She tried to give him the time to sit down command.
Yes, and he pulled his arm away. Oh, and okay, everybody speculated about where he went yesterday. When he was gone, was it yesterday or was it the day before? I forget which day it was now. When he left and he was gone the whole rest of the afternoon.
Yeah.
Okay.
He was gone for a bit.
Mm-hmm. Yeah. Here's the tea on Hunter. I should start my own PI business. He has back issues, so he had to go have his back checked out, and he is currently wearing a back brace.
Okay, that adds up. The judge has been sympathetic to that, and there are times when he's saying, "Mr. Hunter, if you need to, you can sit while making an argument."
Yeah.
So that adds up. All right, let me keep digging here. I'm trying to find. There's a few super chats in. I wanted to make sure I got those. Jules, I'm going to be researching here, seeing if I can see where the judge actually admonished Mr. Hunter. See if we can get another screenshot of another funny face. Last time was a wink. This time is going to be a scowl. But thank you very much. I don't know when it's going to end as far as the break, but
I don't know either. Oh, and 12 was standing throughout the entire deposition. He literally left the jury box and stood at the door, in the doorway of where they come and go. And and he was standing there watching. Yeah, the jury doesn't like, they don't like depositions.
Just feel
so
free to wander about the courtroom, I guess. That's what they can do.
Well, as long as you stay in your little designated area, they're not allowed out of their designated area. But yeah, okay. Well, that's it, guys. Have a great day.
Thank you. We'll see you, Jules. Appreciate it. Bye.
All right. Bye bye.
Okay, I'm scrolling, looking for this this actual clip where Mr. Hunter got admonished. See if we can find it. 11940. Give me a minute. That's on the Tampa's feed. I need to keep one of the feeds up and running, so give me a minute here. Let's see what this one says. Okay. I think I found it. Just one second. Okay, here we go. Let me bring this up for you. Just one second. Got it. We're going to where are we going to jump to? Let's jump to 2.
Mr. Shaw.
And we still are working on the redaction.
We could.
So
you want to play, Hannah?
I'm going to show him his prescription.
I'm going to show him the prescription. Watch Mr. Hunter's face.
As I've told the lawyers, you can pretty much refresh recollection, but when we do it, let's not carry our script right next to the jury and wave it to the jury as we walk by the jury, which I think I've been always saying.
I can truthfully tell the court that never crossed my mind.
That's fine. I just wanted to remind so we don't do that. Mr. Hunter, please don't look at me like that.
Mr. Hunter, please don't look at me like that. That was it. So let's jump back to real time here. See, I think we're right here. But that was how that ended. But looking for that, just going back and rewinding and watching Mr. Hunter's face, because a lot of times I wasn't paying close attention before, there was a lot of expression leading up to that. That expression was just like one of like 50 in a series of scowls and frowns and just general discontent that Mr. Hunter exhibited during that whole argument. But please don't look at me like that. New soundbite. Oh, the soundbite I want, if somebody could... If you could find this on any of the feeds, or on Tampa or LNC or wherever you find it, we just need the audio. I'm looking for the feed of Mr. Anderson, and I think it was yesterday or the day before when he said, "Who elected you to be judge?" or something like that. It's sort of like a "Who died and made you king" moment, and it was a question he was asking one of the witnesses. Possibly, was that Sally Smith on cross? It might have been Sally Smith on cross, but. If somebody can find that and tag me in it, like if they're on Twitter or something, that would be great. I'd see if I can make a soundbite out of it. He said that to Sally Smith. Nick, yeah, that's the one. If I can find it, if it's Sally Smith during the proffer, that's pretty easy to find. I can hunt that down. I just need to set aside the time to do it. I like to have some soundbites like that. I need to mix up my intro because we've got a few sort of stale soundbites when it comes to that. All right. It was Sally Smith during the proffer. Thank you, everybody, for the answers. Let's see. Did I miss a comment? I think somebody just had a memberversary comment that I skipped. I saw, sir. Let's see. Whimsical Druid, approximately 1 hour, 21 minutes ago, and you used your 4-month. Look at this. Use your 4-month anniversary message to help me out find the clip. Thank you very much, Whimsical Druid. Appreciate your continued support. Mr. Hunter, please don't look at me like that. Healing vibes for Mr. Hunter. Yeah, he's got to be. Back problems are the worst. I mean, the worst I've had to deal with. I realize that on the scale, when you look at the scale that of Maya's pain in the chart, where kidney stones and CRPS is, back problems are not the worst on that scale. But working through back problems can just be such a pain, literally. And having to stand up and sit down and move, and wave your arms and everything else, and deal with pain is not fun. Let's see. Rob will be doing a recap tonight, 8 p.m. Sounds great. I'm going to pop over as soon as our podcast is done. But you can catch our podcast either live or on replay. It doesn't matter either way. Doors open. Judge is coming back in. We might have successfully navigated the break.
Ms. Lawrence, you're in control. You're the only one at council table.
She says, I don't want this power.
Is Mr. Anderson joining us, or
he's not going to join us the rest of the afternoon? He had to go prepare the rebuttal case.
Today's Friday, right?
Yeah, okay. Ask him
I just want to check on an exhibit, Judge.
Sure.
Mr. Anderson, I made a deal.
I heard Mr. Anderson and I made a deal. Mr. Whitney's laughing. All the mics are off. If the judge was angry before, he seems to have reset, as he's been able to exhibit a skill that he's able to use several times in this trial when he's been frustrated. Ariel, I was going to make a little joke and wonder if he got ketamine, but I figured that would be a little too soon. So I won't go there. I probably already went too far. Here's Jules' TikTok account. We love Jules. We love that she's able to give us these reports from the courtroom. If you are on TikTok, and it would be awesome if you could give her a follow. Blind Gossip over there on TikTok. There's the link in chat. I think there's a psychological component to Mr. Hunter's pain. Petrified. This is so harsh. I should not be laughing. I should not even have that on the screen. It is funny at the same time, just a little bit. All right, where are we at? It was during Beatty's proffer. We got that one. Let me catch up. Okay, future. Thank you very much. Let me write this in my notes. That'll make it a lot easier to find. So you're on... this is on my video, 4 hours, 14 minutes. That was the Sally Smith cross. Or proffer. Okay, I'll see. I'll have to listen to it and see if it's a soundbite we can use. I'm very picky about my sound bites. They need to be very clean, because when you isolate a sound like that, it takes work to get it to play well in isolation and still sound good. Thank you, Future. Appreciate that. Oh, look at that. Joe CH. Joe CH came in and says, who elected you? Day 24.
Ms. Corrales.
Yes, Your Honor. Yes, Your Honor.
Hey, you said you wanted to do something, so...
Oh, okay. No, I was just going to tell him report our plans to publish an email and then play deposition, and that would all be all we would have?
Likely.
Yeah.
We might play 30 seconds of one of our exhibits, but yes.
And the one that you're going to publish is in evidence?
Yes.
Yes, I just confirmed.
What is the time breakdown for Dr. Hannah's deposition?
Yes, Your Honor. The defense used up 17 minutes, plaintiffs 16. Those are approximations, not too far off.
Well, we'll round to 15. And for this next one, who's the next deposition?
The next deposition will be Dr. Elizabeth Byrne. Defense 24 minutes, plaintiff 20 minutes.
20?
Yeah, defense 20 minutes. Sorry, defense 24 minutes, plaintiff 20 minutes.
And I'm sorry, who's the person again?
Yeah, her name is Elizabeth Byrne, B-Y-R-N-E. She's a physician at Lurie Children's.
Are there any issues we need to address before we
bring the jury back in.
Can I see the email you're going to publish?
Yeah.
I just gave it back to the clerk, sorry.
I can put it up if you want.
We could put it up if you'd like.
3232-141.
What is it?
It's one of the ones.
It's
the Facebook one.
It's a Facebook posting.
Okay.
There's 2 pages if you want to put them side by side. They were admitted yesterday or the day before.
Right. I recognize.
They're short. This won't take too long.
So the next one is a Dr. Elizabeth Byrne from Lurie Children's.
Okay. We are ready to bring in the jury, Your Honor.
Let's bring in the jury.
Okay. I'm excited about these sound bites. I'm not excited about how much time the plaintiff has used. 26 minutes just in depo, plus another 30 minutes in cross. So they're well over, probably an hour, close to an hour and 10 minutes right now. Today, we have one more depo to play, which was, I guess that might be, I think that might be included. The 24 and 20 might be the depo that's coming up. So that can be the 44-minute depo. We had 2 depots. We had a 17 minutes for defense, 16 minutes for plaintiff, and then we have a 24 minutes for defense and 20 minutes for plaintiff. I think that's the one we're about to hear. We heard the shorter one, maybe? Maybe I'm wrong on that. Anyway, the judge will give us the clock when he add it all up.
Want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And you did not see any clips from the media. Is that correct? Correct. And no one's approached you. Is that correct? Mr. Shapiro.
Thank you, Your Honor. At this time, the defense would like to publish Defense Exhibit 3232-141.
If it's in evidence, go ahead.
Thank you, Your Honor.
There's a zero chance, pretty much, that they've settled. The family wants this to go all the way to jury. They want a verdict. Here we go. This is a status update. Thanks for your prayers and support from Maya and us. We appreciate it all greatly. Update: we've been in Tampa since Monday. Monday, Maya has had RSD specific testing done. Visit with Dr. Kirkpatrick. We had to find a new hotel to stay in since Maya became sensitive and allergic to the odor in the room. I think there was animals in there before. I was with her alone that day, which made it even harder to look and change hotels at that time, but we made it happen. Tuesday was a very rough day for me and Maya as well. She received first ketamine infusion times 4 hours. We were there for 6 to 7 hours. Tuesday was a lot harder than I expected. She had hallucinations with monsters, which made her feel very scared and terrified. She mumbled and repeated words constantly, had double/triple vision. I was mentally, physically exhausted. Jack was home with Kyle, so I had no one to lean on. It was just Maya, ketamine, and me taking this curvy, bumpy road to fight against RSD/CRPS. Wednesday was a little better. It was mentally prepared after the Tuesday experience with ketamine. SE. Also, I summoned Jack to help with Maya. Also, my sister with family flew in from Chicago to help with Kyle. That's all I got. Sorry. This is already in evidence. It was read previously, says Emma. I don't think the family would be happy with the $1 million settlement, especially if there was a finding that the hospital was responsible for Beata's death. I don't think that makes the statement that they would want.
Yeah, we'll go to...
Are we ready, members of the jury?
Clay, if we can go to 142, please.
Can you put them up side by side? Another juror would like to see.
Sure. If you can put them up side by side, Clay, that'd be great.
Renee Smitty says, will you do an audiobook? What book do you want me to read, Renee? I can't read any books unless they're like over 100 years old on YouTube because of copyright restriction. So it would have to be like, I don't know, War and Peace. I mean, How far would you go? How far back do you want me to go? Crunchy Frog, the family may regret not taking an offer. It's possible. If the jury sides with the defense, they might look at that and say, well, we had an offer that we should have accepted. Could do some Poe. Quoth the Raven. Is that what you're saying? Yep, the Raven. Lord of the Flies. When was Lord of the Flies written? Are those over 100 years old? I don't think that one is. Winnie the Pooh. A little bit of Milne. The dictionary would be good. Who says that? Who says I should read the dictionary?
Are we ready? Mr. Shapiro.
Sure. I have one more Friday afternoon matinee. So we're going to call back deposition Dr. Elizabeth Byrne from Lurie Children's Hospital for treatment of July 2015. Her deposition was taken on January 31st, 2022.
And members of the jury, I assume you want to keep the lights on. There we go. You may proceed.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do swear.
Likewise. Can you please give me your name and professional address for the record, please?
My name is Elizabeth Ann Byrne. My professional address would be 333 North San Saba Street, San Antonio, Texas, 78207, I believe.
I understand that you're a pediatrician. Is that correct?
That's correct.
Okay. Can you please give me the benefit of your education and training from where you went to undergraduate all the way through any residency or fellowship training that you may have obtained? And
I attended the university.
She attended the universe. We're pausing now for dramatic effect. Let that sink in.
That was really short, Judge. There's more.
Hey, it's Friday afternoon.
Sorry.
Jurors, do you have any questions on that one?
It is under an hour, just so.
Assuming it plays.
Yes. Thank you.
So all we got was her name and that she attended the universe.
Trouble? Okay. Do you need to restart?
I do.
A couple minutes? Okay.
We have a PC that crashed.
Unfortunately, a computer glitch, you needs 2 minutes to restart. So.
It's definitely PC. If you had an Alienware
Restart
computer,
it as quickly as possible.
it would not have crashed. So here's where the Alienware guy is like, yeah, mine doesn't crash. Let's talk amongst ourselves. I think I will read Night Before Christmas, the scientific version to you before Christmas. The one that was the nocturnal segment of the diurnal period immediately preceding the annual Yuletide celebration. And throughout our place of residence, kinetic activity was not in evidence among the possessor of that potential, including that species of domestic rodent.
While we're doing this on Tuesday, which is October 31st, I'm going to need to know if anyone needs to leave early because of any sort of Halloween activities.
They're all going to be in costume.
When I say leave early, that means you still have to come.
What's the difference in the two answers?
Depends. In all seriousness, if we need to work around anyone's schedules, I'm going to need to know that hopefully by Monday morning. But if there's not a schedule to work around, then we won't. Having said that, I haven't been told by my wife as to what my schedule is.
That's what the real thing is.
We're good now? Take two.
Graduated in May of 2007 with a Bachelor of Arts in Psychology.
University of Notre Dame is the answer.
From 2008 to 2012, I attended the University of Texas Health Science Center at San Antonio, where I received my MD. I was in a dual degree program, so I also attended the University of Texas Health Science Center at Houston, but in the San Antonio Regional Campus from the same time, where I received my Master's of Public Health. After completing my medical education, I started residency with McGaw Medical Center of Northwestern University at Ann and Robert H. Lurie Children's Hospital of Chicago. I completed my pediatric residency in June of 2015. And then, oh, sorry, go ahead.
I was going to say, and I understand you were also the chief pediatric resident thereafter, were you not?
I was one of the chief pediatric residents.
Can you give me an idea of what your current employer and position is?
I'm an assistant professor of pediatrics at the Children's Hospital of San Antonio. I'm employed by Baylor College of Medicine, and I currently work as a pediatric hospitalist.
Okay, what is a pediatric hospitalist?
A pediatric hospitalist is a pediatrician who specializes in the care of patients admitted to a hospital.
Okay. And how is it that you came to be involved with the care and treatment of Maya Kowalski at Lurie Children's Hospital back in July 22 of 2015 and thereafter?
She was admitted to my service. I was the admitting attending for the general pediatrics team, and she was admitted to my service.
What does it mean that she was part of your service?
It means that she was admitted to my cohort of patients under which were under my care.
Can you explain to me how it was that Maya Kowalski came to be part of your service?
My understanding is that she presented to the emergency room at Ann and Robert H. Lurie Children's Hospital of Chicago, and was deemed to be appropriate for admission. And at the time of admission from the emergency room, she was assigned to my team.
Okay. And did you arrive at any diagnostic conclusions during your workup of Maya Kowalski at Lurie Children's in July of 2015?
After evaluating her, my clinical finding was that I did not find an organic etiology of her pain and felt that she needed multidisciplinary care.
Am I correct that Lurie's involvement was for a second opinion for a 1-month history of generalized weakness and pain?
That was my understanding upon her admission.
Under general, I see here in your note that you document that Maya, quote, occasionally pushes herself off mattress with hands. What is the clinical significance of that entry as it pertains to Maya Kowalski?
So in order to be able to push oneself off of a mattress with your hands, you need to be able to have enough strength within your arms in order to be able to counteract your body weight and lift your body up off the mattress.
I also see under general, under your physical exam, that Maya was, quote, distractible with questions about school and extracurricular activities. Do you see that?
Yes.
Why is this being included in Maya Kowalski's chart?
When we speak about somebody being distractible, what we are just trying to highlight is that when we were able to ask various questions, they are distracted away from other complaints.
Moving on down to the abdomen here, you indicate that it was soft, non-tender, non-distended, normo-active bowel sounds, and the spleen and the liver were not enlarged. Is that correct?
That is correct.
Am I correct in assuming that Maya was able to tolerate an abdominal examination?
That's correct.
And then if I move down to extremities muscles, the last sentence under extremity muscles says, quote, any touching/passive movement by parent or examiners causes patient to cry. What are you describing there?
You'd have to, what I recall is that any touching or passive movement caused the patient to cry.
Fair enough. Do you have an independent recollection of your interactions with Maya Kowalski or her mother, Beata Kowalski, separate and apart from what you have documented here in your chart?
No, I documented.
Okay. So in other words, you're going to be chart driven, as we say in our industry.
Mm-hmm.
Under the physical examination section, neuro, we'll start here. It says, when Babinski attempted. What is Babinski?
Babinski is a physical exam maneuver where you can look at a neurologic response whenever you are applying pressure to the base of the foot to see which ways the toes move.
And when the Babinski was attempted with Maya Kowalski, what response did it elicit?
It is not documented what response it elicited in regards to the Babinski reflex, but what it did elicit was for the patient to forcefully kick at the examiner with her right lower extremity. RLE is an abbreviation for right lower extremity.
And what does it mean to say 5/5 strength in knee ankle extension / flexion?
That 5 out of 5 strength is complete strength.
And why was that something that would make its way into a neurological section of a physical examination?
Because when it would be appropriate to comment on the strength of a patient who's coming in with a complaint of possible weakness.
Did you see any abnormalities here in terms of right lower extremity strength?
No.
Is that a no?
That was a no.
Okay. At 5 out of 5, is that normal strength?
That's normal strength.
And then you note here, no truncal ataxia, holds head upright and sits upright without difficulty, initially in wheelchair, but as mother reaches for doorknob, patient slumps over, says, "You were supposed to hold me up." What is being described in this portion of the note?
What is being described in this portion of the note was that as referenced by the record, that the patient was sitting up and then slumped over.
You note in there that her workup so far has been unremarkable and she is distractible on exam with good strength. What are you trying to communicate in this portion of your note?
So that thus far there had been a reassuring workup and that the patient had exhibited moments of being distractible.
Thank you very much. And then at the very end of the impression, it's documented here, quote, her exam is not necessarily consistent with her history, which raises concern for a psychiatric component to her presentation, and specifically conversion disorder. Do you see that?
Yes.
What is being described in that sentence of your impression?
That there was a concern that there was a psychiatric component to her presentation.
Namely a conversion disorder?
Namely a conversion disorder.
And what is a conversion disorder?
A conversion disorder is a situation where a patient presents with physical complaints that are triggered by psychological component or nature.
And what type of consultations did you order for this hospitalization?
As I recall, I believe we consulted medical psychiatry. I believe we discussed, but I cannot recall if we consulted pain management and social work. I referenced wanting to discuss with PST, the patient safety team.
Towards the bottom of LCH 144, you note that though she reports significant weakness, she is noted to have appropriate strength when distracted. What does that mean?
That means that the patient was reporting that she was weak, but whenever I was able to distract her, I was able to see physical exam findings suggesting that she had normal weakness.
At this point, were you thinking this could be a complex regional pain syndrome patient?
I was not.
Why not?
Her constellation of physical exam findings and symptoms was not consistent with complex regional pain syndrome.
What about her constellation of symptoms was not consistent with CRPS?
She seemed to have pain with light touch in a variety of areas. In my prior experience with patients with complex regional pain syndrome, did not have that distribution of pain.
And did you continue to follow Maya Kowalski over the next few days?
I did.
Okay. Well, why don't we turn to your next note that you have here. And I believe, unless you can show me otherwise, your next involvement would have been a pediatric daily progress note from July 23 of 2015. Am I correct? It says here subjective. Oh, well, again, you're the admitting attending here, right, Elizabeth Byrne?
That's correct.
And it says subjective. Overnight, Maya was noted to fall out of bed and had a headache following the event. Do you recall anything about this fall?
I did not recall the fall. However, there was multiple event notes documented, which I reviewed.
Okay, and what did you recall after reviewing those event notes?
That the patient had a fall, an unwitnessed fall out of bed.
Fair enough. All right. And it looks like you would have done another physical exam on this day. Is that correct?
That's correct.
All right. You note that she was awake, alert, crying in her bed, but answers my questions. Am I reading that correctly?
That is correct.
And then you note neuro, patient says she cannot move her arms and legs because of the pain, but will roll in bed on her own. What is the significance of that entry in your chart?
That the patient was able to roll around in the bed and so had the muscle strength to be able to do so.
Okay, and why is that something you would have included in your note?
Just sort of highlights that the patient was able to move despite initially saying was unable to move.
And then later on LCH 166, near the top here, you note in your progress note that Maya, quote, continues to report generalized pain and weakness. However, this is not consistent with physical exam findings. What does that mean?
That although the patient continued to report weakness, we had on physical exam evidence that she was able to have strength.
Okay. And at the end here, you document, quote, presentation raises concern for a psychiatric component, such as psychological factors affecting physical condition, such as conversion disorder in the setting of recent illness. Do you see that?
Yes.
Can you please describe what you're explaining in that portion of your note, please?
What I'm describing in that portion of the note is that I had a concern for a psychiatric component, such as conversion disorder, affecting her clinical picture. Okay. The part such as psychological factors can reference any number of psychological factors as a trigger for conversion disorder.
Okay. All right. And I noticed that you put it in a consult for RIC. Is that the Rehab Institute of Chicago?
That's correct.
Under psych here, what did you note?
Consult for possible diagnosis of conversion disorder / psychological stress.
Okay. And so why under your plan did you want to have a psychological consult?
Because I wanted the psychiatrist's input about whether the psychiatrist felt like there was concern for diagnosis of conversion disorder / psychological distress.
Okay, and why did you place a consult for RIC's involvement?
RIC's involvement, because the patient was coming in with physical complaints, and often we consult rehab in order to help with coordination of improvement in functional mobility.
Okay, and am I correct here that you also involve social work?
That is correct.
And what is Child Life?
Child Life is a professional within pediatric hospitals who are trained in helping pediatric patients cope with their hospitalization, among other resources that they provide.
Okay. And you also advocated for music and art therapy, I believe?
That's correct.
As well as PT/OT. What's that?
Physical therapy and occupational therapy.
Okay. And I note also here on LCH 166, do you indicate, quote, given lack of organic etiology for her pain, had a meeting with Maya, her mother, and social work to discuss plan of care, end quote. Do you see that?
Yes.
What do you mean, given lack of organic etiology for her pain?
Meaning that I had a lack of a medical etiology for her pain.
Okay. And again, in your addendum, I note that RIC has been involved. And what did they recommend?
Per my note, it says outpatient rehabilitation.
Okay. And I understand you have a daily progress note from July 24 of 2015. Is that correct?
Yes.
And it says here, Dr. Revivo from RIC discussed treatment options for her with the team and had a conversation with mom over the phone. Do you see that?
Yes.
All right. And it says the need for non-acute inpatient pain treatment was endorsed. What does that phrase mean?
That means that the patient did not need to be inpatient for the pain treatment.
Okay. And did you identify any rashes or lesions on the patient's back or extremities?
No.
Okay. And then what was the result of your neurological assessment here from the 24th?
That the patient was stating that she could not move her arms and legs secondary to pain, but when distracted was able to move them.
Okay. And what's the clinical significance of that as a pediatric hospitalist?
It just indicates that a patient does have the ability to move their arms, even though they're reporting pain.
Okay. And then you note presentation raises concern for a psychiatric component, such as psychological factors affecting physical condition, such as conversion disorder, in the setting of recent illness. Do you see that?
Yes.
Okay. And is that, again, you're leaning towards a conversion disorder?
Correct.
So it looks like we've got a note here on LCH 154 from a Kelly Lowry, PhD, 7/24/15. Do you see that?
Yes.
Okay. And based on your review of Dr. Lowry's note, what was Dr. Lowry leaning in favor of here?
So Dr. Lowry's impression was that psychological factors could be contributing, possibly through maintenance of pain symptoms in response to initial stress or physical change.
And as a hospitalist, you kind of oversee multiple different specialties at times, correct?
As a hospitalist, I consult with multiple different specialties.
We're looking at a pediatric attending addendum, date of service 7/24/2015, signed by Elizabeth A. Byrne, MD, pager number 95209, can be found on LCH 156.
Okay.
And yet you note here her examination remains unchanged. What do you mean by that?
Meaning that she continues to report diffuse pain with light touch, but when distracted, had evidence of being able to move around.
What do you mean here by further diagnostic workup will only delay therapy?
My recommendation was that she have, as you can see, intensive multidisciplinary care involving physical therapy, psychology, and pain specialists. And my clinical impression was that by keeping her inpatient to do additional workup, I was delaying her ability to go and have intensive multidisciplinary care.
So why did you recommend physical therapy, psychology, and pain to assist with Maya?
Yeah, so psychology, because I was concerned about a psychological component to her presentation. Pain, as she was reporting diffuse pain and on multiple medications for her pain management, and physical therapy to help with her functional mobility, as she was reporting that her symptoms were preventing her from being able to have good functional mobility.
At this point, did any of your consultants recommend that Maya undergo a series of high-dose ketamine infusions?
Not to my knowledge.
And I think it looks like here you're saying, quote, given these preferences, recommend discharge. What do you mean by that?
As you can see in my attestation, I offered to transfer her to the Rehab Institute of Chicago, but the patient's mother expressed preference to return to Florida. And so I was recommending to discharge her so that she could establish care with a rehab facility in Florida.
And why is it that you opted against an escalation of pharmacologic therapy?
The patient was already on multiple pain medications. I worried about the side effects of escalating her pharmacological therapy and felt that the patient likely needed additional alternative therapies in order to address her pain.
Okay. And then later on down in your note, it's referenced here, quote, of note, throughout the conversation, Maya was lying in bed and persistently vocalizing, quote, ow. When I discussed the need to continue to address other components of pain with child life, art therapy, and music therapy, she abruptly ceased saying ow and stated, I no longer want child life. I can't be distracted, end quote. Do you see that?
I do.
If it's in quotes here, am I correct that Maya stated that verbatim?
Correct.
And then it appears as if Maya said, quote, she began to cry and state to her mother that, quote, she would like to leave the hospital and return to Florida as, quote, they only think there's something wrong with my head. There's nothing wrong with my head. Mom, I only want to do this with you. If that's what it takes, then we'll do it. Book the flight now, end quote. Do you see that?
I do.
Okay. And what were your discharge diagnoses after or around the time you were discharging Maya on July 24, 2015?
That is likely a misspelling. Steroid-induced myositis now resolved with exaggerated psychological stress response resulting in increased pain.
What does that mean, this exaggerated psychological stress response?
That there were psychological components.
Did you notice any asthma attacks or issues with respiratory function during the course of this hospitalization?
Not that I recall. And typically if a patient were to have an asthma exacerbation, I would document that in the chart.
And it indicates here her admission electrolytes were W and L. Is that within normal limits?
That is correct.
All right. And it says no imaging or further investigation was indicated due to patient's ability to move appropriately when distracted from her pain. Do you see that?
Yes.
What are you explaining? What are you explaining there?
That given the patient was able to move appropriately when distracted, that additional workup was not indicated.
Okay. All right. And am I correct that the plan here was to do some type of inpatient program near the patient's home?
Yes, that's what the plan says.
Okay. And what was their opinion?
You'd have to reference the medical chart.
So what is the direct, can you read the direct quote from the psychological services involvement with Maya Kowalski into the record, please?
Their opinion is as follows, quote, our initial impressions at this time suggest that psychological factors could be contributing, possibly through maintenance of pain symptoms in response to initial stressor or physical change, in parentheses, such as an episode of myositis, and parentheses. We recommend 1, support for consultations from art therapy, music therapy, child life. 2, consider consultation with rehab for intensive treatment focused on return to functional mobility. 3, consider multidisciplinary team conference to discuss diagnoses and treatment recs with the family to prevent, to prevent against any misunderstandings. And 4, we will continue to follow to provide ongoing assessment of symptoms and begin to introduce non-pharmacologic approaches to pain management, as well as parenting strategies likely to reduce unintentional reinforcement of pain behaviors.
What consults did you order during this hospitalization?
Psychiatry, physical medicine and rehab, physical therapy, occupational therapy, and pain.
Upon discharge, did you do a physical examination?
Yes.
Did that include vital signs?
Yes.
Does that include a blood pressure?
Yes.
Do you see any abnormal vital signs here upon discharge?
No.
All right. Was Maya able to tolerate an abdominal examination upon discharge?
Yes.
Okay. Extremities muscle, it indicates full range of motion of all extremities. Do you see that?
Yes.
What does that mean?
Patient has full range of motion of all extremities.
Meaning what in lay terms?
Patient's able to move their arms and legs fully.
Okay. Skin, you note normal. What does that mean?
No rashes or abnormalities noted.
If you had noticed some rashes or other abnormalities, is that the kind of thing you would document in a discharge summary?
Yes.
Under neuro, you indicate that the neuro exam was, quote, complicated by lack of patient cooperation, though patient alert, interactive, normal tone, moves all extremities well when observed, complains of weakness and moans in pain during examination, thus examiner is unable to fully evaluate strength. Do you see that?
Yes.
At the end of all of this, what is your ultimate impression and plan for Maya Kowalski upon discharge here?
again, that the again, my clinical impression is that her exam is not consistent with her history, which raises concern for a psychiatric component to presentation and specifically conversion disorder.
And what did you, in terms of a plan moving forward, recommend for this family?
A therapeutic program that combined physical and psychological therapy techniques.
Did you see any need for this patient, doctor, to have a ketamine coma?
No.
Ms. Byrne, were you a resident at the time you created all the information you put in the Luria medical records?
I was a chief resident, but I was an attending physician.
Well, how many months had you been out of medical school? Or were you still in medical school technically?
No, I graduated medical school 3 years prior.
All right. And to that point, you had not gone out into private practice, I take it?
No.
And you were still serving as a resident, meaning your only employer was Luria's, correct?
My employer was the Pediatric Faculty Foundation.
Ah. And who are they?
That is the physician group that my understanding was contracts with Lurie. I had completed my residency.
When did you complete your residency?
In 2015.
What month in 2015?
June.
So you saw Maya for the first time in when? July?
July.
So you had been out of your residency for 2 months, is that right?
About a month.
Mm-hmm.
Okay.
Well, can you tell me now, since you had offered some opinions there, please tell me the DSM-5 criteria for conversion disorder.
I do not have it committed to memory.
Well, tell me one.
My apologies?
No. Tell me just one symptom, one functional neurological symptom of conversion disorder under DSM-5.
I'd have to reference the official manual.
All right. Tell me then, what are any signs of complex regional pain syndrome?
It can be pain with light touch. It can be focused to one limb. It can be variable in presentation.
All right. Anything else?
No. It's variable in presentation.
What is allodynia?
I'm not sure.
That's one of the key symptoms. It's a light touch causing pain, unexpected levels. So you're saying she had that?
She did.
Right. Is it just possible that this was the beginnings of dystonia?
It was not consistent with examples of dystonia that I have seen, as her feet were not consistently plantar flexed.
Did pain management do a consult on this?
I believe pain was consulted.
When you say a consult, my understanding is where the physician comes in, examines the patient, makes those tests that are reasonably necessary, and does a differential diagnosis to come up with a working or eventually, I guess, firm diagnosis. Is that your understanding?
Yes.
So are you saying that you had a pain management expert come in and do a full physical examination of Maya Kowalski?
I consulted the physical pain team, the pain management team, excuse me. And I was not present at the time of their consultation, so you'd have to ask them.
I consulted and I was not present.
You ordered also a psych consult, is that right?
That's correct.
Now, and who was that by?
As per the medical record, it appears like Kelly Lowry, the psychologist, did the consult.
And do you know Kelly Lowry?
It's been several years, but I have talked to Kelly on the phone at that time.
She was a PhD psychologist, was she not?
I believe yes, I believe so.
As opposed to an MD, which would be a psychiatrist, correct?
That is correct.
All right. Well, I didn't see any indication of Ms. Lowry spending time with Maya. Do you know if she ever went in and did a full interview of Maya for the purposes of rendering a psychological diagnosis?
I do not know.
For whatever she did do, though, she did not come up with any real diagnosis, did she?
You would have to ask Dr. Lowry.
Well, you just went through the records. Correct me if I'm wrong, but I didn't see any diagnosis from Dr. Lowry. Did you?
I saw what she documented in the chart.
Right. No diagnosis. She did not confirm a diagnosis of conversion disorder, did she?
Again, you'd have to talk to Dr. Lowry about her diagnoses.
I'm just asking you in that section about Dr. Lowry's involvement. Would you agree with me? There is no DSM-5 diagnosis listed there.
I read her clinical impression, but I do not recall seeing her say a specific diagnosis.
And to this point, did you have any specialization, or were you working towards any specialization in pediatric psychology?
No. Are you asking if I had cases before where I had a clinical suspicion or concern for a psychological disorder?
Sure. Suffice it to say, you had never made a, quote, diagnosis like this before in your life, had you?
Of expressing a concern for conversion disorder?
Let me ask then, how many patients had you diagnosed with conversion disorder prior to seeing Maya Kowalski?
So I guess what I would say is that that is a diagnosis that's made in conjunction with the specialist.
All right. So the jury understands then, by Luria's own rules, for there to be a confirmation of conversion disorder, you'd have to have a child psychologist or psychiatrist come in and do the final diagnosis, wouldn't they?
I don't know that I would. I often psychiatrists are involved in these cases.
Well, that was not my question. The question was, from your experience there, Luria's Children's Hospital did not allow a diagnosis of a psychiatric or psychological disorder to be made absent a consult by a PhD psychologist or psychiatrist. True?
I can't comment on Lurie as a hospital's, because I can't comment for every clinician there.
Well, you just spent a little bit of time here explaining about your duties and your role as a hospitalist. Aren't you familiar with Luria's rules, regulations, manner of doing things in reaching a diagnosis?
I am familiar with some of the clinicians' manners.
Okay, then are you saying that Luria's Children's Hospital allows residents to be the final say on diagnoses of a psychological or psychiatric nature?
No, as a resident, you have an attending physician.
Did you ask about changes in sweating or sweating asymmetry?
I do not recall if I asked about that.
Right. Did you ask Maya when it hurt as opposed to where it hurt?
I do not recall how I asked about the timing of the pain, but I do feel like I do not recall specifically. I would have to review the medical chart to see if it was commented that she said that she was in pain always. That was my impression.
Maya was on pain medicine at this time, was she not?
She was.
Well, did you time any of your review of Maya to when she had her pain medication?
I do not recall.
Well, if the child just had pain medication, it would be likely she'd be suffering a little bit less, correct?
In general, it depends upon the type of pain medicine and whether or not that pain medicine is appropriate for the type of pain someone's presenting with.
Well, Luria's Children's Hospital wouldn't give her an inappropriate medication, would they?
I believe that she was continued on her medications from the outside hospital.
And then tell us all of the ways you determined that Maya had weakness in all four limbs.
So in order to assess for weakness, one does a physical exam to look for strength. As was documented, the patient was not cooperative with the examination in order for us to test individual muscle groups. However, as was documented, on multiple occasions, she was shown to be able to demonstrate strength because she was able to, for example, lift her legs anti-gravity in order to kick forcefully.
So she was protective, and you didn't feel that it was necessarily to be protective, but she was protective, was she not?
You would have to ask Maya.
Well, when you wanted to do certain exams, when you wanted to touch her in certain ways, she reacted as though she was already in pain, did she not?
As was documented, the patient verbalized saying, ow. And at other parts in the chart, as was documented, the patient was crying and moaning.
And she had, by her complaints, continuing pain, did she not?
I'd have to review, but that was my impression.
And from your history, this appeared to be disproportionate to any inciting event. In other words, you couldn't pinpoint how the pain started, right? And you already testified that she had hyperesthesia, right? She reacted really out of the ordinary, out of what you would expect to being touched, right?
As you'd have to refer to the medical record, but as was documented, the patient stated that she had pain with light touch.
She also had allodynia, as you stated, right?
Mm-hmm.
All right. Did you specifically look for skin color changes during the time she was there?
Yes.
And she reported decreased range of motion, did she not?
I'd have to reference the medical record.
Well, didn't you say that she reported to you that she had difficulty moving her arms or legs, things like that?
Yes, that's correct.
Okay. Did you do a pinprick test anywhere?
I do not recall.
Okay. By my count, you just said that she has all of the, sufficient number of symptoms and signs for confirmation of CRPS. Whether she did or didn't, did that ever cross anyone at Luria's mind?
Can you repeat the question, please?
Well, there are a certain number of signs and a certain number of symptoms at the time in order for diagnosis of CRPS. Do you agree with me? There.
For a diagnosis of CRPS, yes, there are signs and symptoms.
Okay. And there's 3 or 4 of different categories, but you pointed out hyperesthesia, allodynia, decreased range of motion, motor dysfunction, and I don't think you checked for the rest of them. So wasn't there enough there to get a consult for somebody that knows CRPS?
The patient reported decreased range of motion, but was able to exhibit appropriate range of motion. In regards to if I have a clinical suspicion for CRPS, which I did not based off of her physical exam and find symptoms, then yes, I would in general consult a subspecialist.
Did a pediatric neurologist ever examine her for what she complained of? Not what you thought she complained of or what you thought she could do, but what the child could.
During her hospitalization, she was not examined by a pediatric neurologist, to my knowledge.
Well, did you have a pain management specialist, somebody who might know something about CRPS, examine her, not about what you said she was doing, but about what Maya said her problems were?
I had a pain management specialist consult on her.
Right. So, can you remember whether the pain management specialist made any firm diagnosis of what was wrong with Maya?
I do not recall.
Okay. And after looking into it, you still had no one that you can tell us who confirmed a diagnosis of conversion disorder.
Do not recall if anyone specifically put a diagnosis of conversion disorder in their documentation. Did I put down Munchausen by proxy? I did not.
Okay. Apparently none of them rose to a particular concern other than your suspicion of conversion, right? Have you followed Maya since this time?
No,
You know what happened to this little girl and her family?
I do not.
How many papers have you published in the area of child psychology or psychiatry?
0.
How many talks have you given?
0?
Well, what training do you have in complex regional pain syndrome other than whatever you learned in medical school?
Training is that of what I learned in medical school and what I've learned at the time, what I learned in my pediatric residency.
So no papers and no talks, and no clinical studies, none of that, right?
No papers, no talks or clinical studies in regards to.
Complex regional pain syndrome.
That is correct.
So then, in terms of Maya's actual diagnosis as opposed to suspicions, would you defer to the attending physicians that followed Maya thereafter for longer periods of time, who had specializations in these areas?
I can't comment on Maya's diagnoses after she left my care.
Why did you think it was suspicious for Maya to stop crying to explain to you where she hurt?
In patients with significant pain, in general, they are not able to stop crying in order to answer questions.
Well, when you say stopped crying, are you saying her face miraculously dried up and she had a bright smile on her face and she was no longer sobbing and was just perky? She stopped sobbing long enough to explain.
As I recall, she had a pause in the facial grimace and moaning and was able to converse with me in a comfortable fashion.
Was she crying before that?
She was crying and moaning.
So she stopped moaning long enough to explain to the doctor where she hurt, right?
And grimacing.
That's the end of that presentation.
Yay.
Anything else today?
If you would indulge, I have about 1.5 minutes of video to play before we conclude.
Oh, we can do this.
I think we can do 1.5 minutes.
Okay, great. Clay, I would like you to play Defense Exhibit 3095, which is a video from May 26, 2017. May 26, 2017, 3095.
Please don't be a music video. Please don't be a music video.
No.
Oh, it's the dog.
I see you.
You know what Kyle does? He just lays down and then she comes and jumps on him.
Come on, please. It's okay. It's okay. It's okay. It's okay.
And then last one, Your Honor, for the day is 3097. And this is October 20th.
This is the high kick, I think.
2017, October 20th, 2017. 3097.
Filmed in 240 frames per second. The flicker is from the lights.
And I think that will conclude the evidence from the defense for today.
Okay. Members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Monday, we're going to be back at the normal time, so ready to go at 9 a.m. Have a wonderful weekend. Thank you very much. We're still on time.
All rise. Jurors exit.
We're waiting. Jury's out of our presence. I was handed a note on October 31st. I'm supposed to take my daughter trick-or-treating, and I guess we're going to hear it. Hang on. We'd like to make that happen. It has to be a certain location by 5:15, so probably need to really think on Thursday.
I'll address it on Monday, but I'm aware. The jury's out of our presence. I was handed a note on October 31st. I'm supposed to take my daughter trick-or-treating and would like to make that happen, and has to be at a certain location by 5:15, so probably need to really think on Thursday. Probably need to be landing around 4-ish.
On
Tuesday.
Sorry, on Tuesday. I apologize. On Halloween.
Yes, Your Honor.
Now, I say that. I don't know if I'm going to have to leave earlier. I haven't been told. I will figure that out.
Okay.
Judge may be told.
Judge,
He has
I'd
to
like
leave at
to
noon.
get admitted Exhibit 3217-0569 through
Everybody can sit down, or they can stand, whatever they want to do. But
0574. It's the exhibit that counsel wanted some redactions. The redactions have been done. I gave it to counsel for his review. Is there an issue?
Yeah, 569 to 574.
Yeah. Is there any issue?
No, I would just say we can call it 3217A, probably.
Yes.
So what am I admitting? What's the number?
Okay, so it'll be 3217A, 0569 through 3217-0574. So there's, I'm sorry. I'll just read out each page. So it's 3217A for all these with the page 05.
Sorry, it's
0573 and 0574.
And that was agreed to?
That's the one where the court order, yes, just say yes.
Over our objection, eventually agreed to.
Yes.
So the court receives, and Ms. Cross, make sure I read this properly, into evidence 3217A, specifically pages 569, 571, 569, 570, 571, 572, 573, and 574.
Yes.
Okay, the shot clock. What did
There
I
we
just
go.
do with it?
I think they have under 3 hours left on the plaintiff side.
Plaintiffs used 1 hour 15 minutes. Their cumulative total is 56 hours 35 minutes. The defense has used 2 hours 5 minutes today, with a cumulative total of 37 hours 10 minutes.
Judge can inquire. It's our
2:25
understanding
left.
that the remaining amount to get up to 59 includes rebuttal.
Well, that is what I have previously said.
Because, right, okay, we just want to make sure, Judge, because the longer the cross is, the harder it is for us to get to close our case. So
She was
we're
asking
all operating
to
under
make sure the other
59-hour
side.
agenda.
We will make a motion at the appropriate time. We have been targeted with our time during the defense's case, but we'll take it up at the appropriate time.
That's fine.
And before such a motion is made, if such a motion is made, please just talk to the other side and see if there's an accommodation or not. But if we need to address it at the time, we'll address it at the time.
Okay.
Anything else I can do other than speak even slower on a Friday afternoon?
Not from the defense room.
What time do you want us here Monday, Judge?
Are we talking 15 minutes or 30 minutes before? I mean, I suspect.
I think 8:30, Judge. We're going to have some exhibits given the witnesses.
And who do we have coming on Monday?
Well, we talked about that earlier, but we are also likely to call Dr. Sharon Levy. She's one of our experts, in addition to.
So Levy and Beatty. Is there anyone else that we need to know of?
We also have a nurse, Kelly Thatcher, who can also testify.
3 witnesses?
Yes.
Oh, well, and then Debs.
Yeah.
3 live.
3 live witnesses.
3 live witnesses, and we'll let you know about that.
Understood.
If we have still time.
And then are we looking to rest on Tuesday or Monday?
Judge, in all honesty, we're not going to be representing Monday. And every day we think we're going to get more done, and we don't. That's part of my comment about,
Now they're going to
staying
Wednesday.
forever. So
I would say this: we're definitely be calling witnesses through Tuesday. Our goal is to rest early Wednesday, but in fairness, it's going to depend how long the plaintiff has in cross on our witnesses. If we can get through 3 live witnesses on Monday, plus play at least 1 to 2 depositions, we should be in a good position to rest by Tuesday. If the plaintiff are taking long cross examinations of our witnesses, it's going to push into Wednesday morning. In fairness, you've seen the shot clock. They've used 57 hours. We've used 36. So
we also have the burden of proof.
I am.
We understand that this court wants us, needs the parties to rest at the end of Wednesday. We understand that.
I am trying to get this case resolved by Veterans Day.
We understand the court's admonition that the absolute target for everyone to be done is so we can close on Monday, is for both sides to rest Wednesday. We're working towards that. But again, if the plaintiffs have another 3.5 hours, if they burn through all of that on cross-examination, they're going to have trouble resting by the end of Tuesday. Anyhow, nothing further after that, Your Honor.
Well, we've been passing notes back and forth when we're at the lectern here, giving each other the hook. So
I appreciate it, and have a wonderful weekend. I'll see everybody here 8:30 a.m. 8:30 a.m.
8:30 a.m. start time on a Monday.
Yes, sir. Have a good weekend.
I know. We're in recess.
All right, we are in recess, and as everyone files out, this is what we want to go over just a little bit. Dr. Elizabeth Byrne, the last doctor from Lurie Children's, very new there, and that's what Mr. Anderson focused on his cross in the deposition. But she was the general. She says did not find organic etiology of her pain. There was distractible pain. The Babinski test, we talked about that, where they put the pressure on the foot to see which direction the toes go, and the response was not which direction the toes go, it was which direction the whole foot goes. It was back at them. She kicked with a 5 out of 5 strength. Let's see. Reverend Beasley says, please, I've been searching for the Psy version of Nightmare Before Christmas. Can you please tell me the title, where to find? I've got a copy, Reverend Beasley. Send me a quick text on the burner phone, and I'll send you a link to the text document I have. I think it's missing a little bit, but I've got it also committed to memory, if that helps. But SB, seriously, welcome to the gallery. Good to have you here today. Thanks for your comments today. I appreciate that, and wonderful that you could join us as a member. That's exciting. Thank you. Judge, talking about time, we heard here at the end of the day that Mr. Whitney was saying, we realize we're out of time. Okay, which they only have, let's see, they've got 56 hours and 35 minutes, which means 2 hours, 25 minutes left for tomorrow, or sorry, excuse me, Monday, which is going to have Kathy Beatty, and Tuesday. And they've got, what, 6 witnesses, 3 by depo or so on Monday, roughly, and then more witnesses on Tuesday. So they are going to run out of time, and the defense did ask the judge, Ms. Corrells, did very nicely couch this as, I'm just curious for ourselves. We're conscious about time here, sitting here with, oodles of time on our hands, days of time left over. We just want to make sure, do you want us to include our rebuttal time in that time? Because that's really to cramp our style. She was not asking for herself. She was asking to say, Judge, you're going to hold them to that time frame. That's their rebuttal time as well, right? and Judge said, that's what I came up with. And Mr. Whitney's like, well, we'll be making a motion because we need more time. And probably it will get sorted out. I don't think it's going to be a huge dilemma, but it's the judge will have some words to say there. We'll see what happens. All right. So is Anderson going to ask for more time since rebuttal is included? Now I'm nervous for him. Yes, they are. Mr. Whitney says they are going to make a motion when the time is appropriate, which means when we're out of time and we need more, we'll make a motion for more. Just want to thank you for all the birthday wishes, says Bug Duggar. The manhunt for my Uncle Fred takes the cake. Rest in peace, Fred. Rest in peace, Fred. Yes, the bug is dead. The bug that was in my house, and that's the way it should be. Let's see. We've got a bunch of new people here today. First of all, thank you. If this was your first day, thank you so much for joining us. We appreciate that. This is a fun community. A lot of times it's we can have a little too much fun, and I apologize for that. If I've been offended anybody in any way where I poked some fun at a situation, we like to have moments of levity as well, because these are sort of very serious trials. But I hope you did enjoy the time here and maybe make a friend or two and chat. We're a pretty respectful group, and we'd welcome you back and love to have you back and join us again. We will be back following this trial on Monday. Tonight we have the Not Relevant podcast. This is a podcast that my friend and I, Thomas, who's one of our mods here on the channel, will be doing tonight at 8 o'clock. I don't know, Rob has a recap tonight, so as soon as my podcast is over, I'll be popping over there to say hello and see what's up, because I'm sure there's going to be some great stuff on there as well. Let's see, Sheila, my first day, wonderful. I hope it was a great first day. I really do. Coffee and Crime, it gives, I think this is like 20 memberships now. Coffee and Crime, thank you very much. Been quite generous with the gifts this morning. A lot of gifts flying out the door right now with gifted memberships. Let's see, is there anything we need to discuss about today, about the events today that I can help with? Let's see, we did the shot clock. We know we're starting at 8:30 on Monday morning. The bug's dead. That was important. If you were here for the bug part, featured prominently in today's show. Lots of fun jury questions. Lots of fun stuff there. Okay. Monday. Kathy Beatty. That's going to be the big one. That's what we're all waiting for. It probably will be a lot spicier than the Sally Smith bit. I think that's something that's going to be pretty impressive, and I wouldn't mind if Mr. Anderson or Whitney, that would be awesome if it's Whitney, used all their time. I think it's going to be Mr. Anderson though. Used all their time, remaining time, questioning or crossing her. What is rebuttal? Is that after closing arguments? P. Will for real. Rebuttal is a time where the plaintiff gets a chance to go back and counter some of the usually it's expert testimony that the other side put on. So usually they'll bring in an expert and say, yeah, they brought this guy that said this. We also have an expert, and he sees things differently, or she sees things differently. So that's what that's for. It usually is drier testimony in my experience. It's not the exciting, riveting, game-changing. It's just we have another professional who sees it differently than your professional. That's what it boils down to, and then the jury gets to choose who they believe. All right, Monday will be spicy. It's going to be great. The objection count. Oh yes, the objection count. Let me put that up here. Just one second. Super source, box source. 2 is 4. Let's go up here. We have 1470 right now is how many we were up to. I don't think I missed too many. If I did, let me know. We'll get it updated. Here we are on our count. Let's scroll really quickly. 1,000, 1,200, 1,300, 1,450. Let's play through here and see who else we had here. Oops. There we go. So here we are, right? Oh man, why did I? Too many buttons. I have a contest idea, by the way. I'm gonna let it out now, but there's no way to enter quite yet. But one of the contests we're gonna do in the future is you get to guess how many buttons I have for my controls. I'm talking everything. I'm not talking the buttons on my cameras. That's the only thing I'm not including. But everything from the button on an iPad to my switcher, soundboard, keyboards, Stream Deck, replay machine, remote controls. We're going to do a quick contest at some point. I haven't even let the mods know yet. But how many buttons do I have to fight with today? Okay. Anyway, that's where we are on the. It looks like Leslie M seems to be winning. You're the closest one. 1471. 1474, Krista, you're coming up next. The Cronow Kids, Candy, Mini Duck, Taminator, Big Rig 33, Dog Mom 3, Iowa Backyard Cam, Nancy Demo. All those guys are coming up soon. Okay, there we go. All right. That being said, we're at the ending point for the day. We're at the ending point. I've got to prep for a little bit more for the podcast tonight that starts at 8. It'll be on this channel. If you'd like to join us, it's a live podcast, and you can. Hey, how's it going? Where's your costume?
I took it off so I could play on the trip. I didn't.
Oh, okay.
Are you almost done?
I am almost done. I'll be done in just a couple of minutes. All right. Love you. Okay, we're just wrapping up here today. We've got a little trick or treat activity tonight that kids are going to take part in as well, which I think my wife is taking them to because I'll be on a podcast, so I don't know how this is going to work. Carol says I'll be on Lawn Lumber. Wonderful. I'll pop in over there as soon as I can. Appreciate Rob. Thanks for hanging out here. Hope your day in trial went well. So that's great that way. I think that's it. I feel like I left something out, but I don't know what it is. So we'll just have to say thank you, everybody. Thanks to our amazing mods. They have gone. They work night and day. They go above and beyond to get this done. Sometimes I'll go live with a story or a police chase or something late at night, and they're just there. I didn't even warn them, and they just show up, and they're like, I know we put in 12 hours today already, but we'll put in another 6. It's not a problem. They're fantastic. Thank you so much. I appreciate their support. Thank you to each of you who come here and join us in chat and make the community what it is. It would not be the same without you. I definitely appreciate you. Tonight when you go home, please hug the ones you love. Smile at someone. Make the day just a little bit better. We hit them as well. We're going to add that just for today only. And please stay safe till we go live again. Tonight it will be at 8 o'clock for our podcast. It'll be about an hour. Then I'll pop over. We'll be over on Rob's channel as well. Hope to see you over there as well. Thank you all. Be kind to each other. Have a great weekend as well. Halloween's coming up. Save some space for candy, right? That's my advice. All right. We'll see you guys. Have a good one. I was going to say something and I just said instead. But have a good one. See you later. Bye.